All right. Good morning again, everyone. At this point, we would like to close our committee meeting for February 18th, 2026, and we'd like to convene our public hearing. I will acknowledge we have a lengthy agenda today. I guess it's the blessing and the curse of being part of one of the largest classes that came through the legislature, I guess, 8 years ago. So be that as it may, we're gonna do our best. All right. With that, we will start with nominations for review to be an associate judge of the Supreme Court and a judge of the Superior Court, the Honorable Stephen D. Eckert of West Hartford. Judge Eckert, if you could come forward. We'll ask folks to give a brief opening statement. I will emphasize brief given the number of folks we have, and then we will turn it over to the committee for questions after that. Before you sit, I do have to swear you in. Sorry about that. Judge Eckert, do you swear or affirm, as the case may be, that the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? Great. Have a seat and just make sure the light is on in front of you on the microphone. Should be a button. No. On the microphone. There you go.
You're good. Working?
Yep.
Yeah. Tell me if you can't hear me. Thank you, sir. And good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and the other members of the committee. I'm Steve Ecker. My wife and I live in West Hartford, having moved up from New Haven a few years back. Truth be told, my heart probably remains in New Haven, where I spent most of my adult life. Thank you for making the time and effort to consider my nomination for reappointment. As an associate judge of the Supreme Court, I understand that your task is of constitutional dimension. Stands as an essential part of our system of checks and balances. And I will attend to any questions that you may have with in that spirit. A few additional words of thanks quickly, if I may. I'm grateful to the Chief Justice and 5 other members of the court for being such superb colleagues. I have great respect for each of them, and I learn from them on a really daily basis. I'm also grateful to Governor Malloy for nominating me to this position in 2018, and of course to Governor Lamont for nominating me for reappointment. It's an honor, indeed. If you'll indulge me as my opening statement, I have about a minute of just a comment on the last point I made, which is that when I say it's an honor to be nominated for reappointment as a judge, I use that word advisedly. I've learned over the past 12 years as a trial judge that it's an honor to be a judge because the role of the judge exists as an ideal in our society. It's an aspirational model of character, of comportment, and decision-making. The judge, now with a capital J, is characterized by absolute fairness and impartiality, wise practical judgment, unremitting civility, acute self-awareness, and the humility that always accompanies such self-awareness, or should, and last but not least, an unwavering commitment to the jurisprudential and political traditions that define the rule of law. As flawed human beings, we may be incapable of fully attaining that ideal. I know that I'm not there yet. The important thing in my view is that those of us fortunate enough to be appointed as judges strive to fulfill it in our thoughts and actions every day, and don't make the grievous error of thinking that we've reached that goal and that we have no need to keep working toward it. So that's, thank you very much with that. I do have one correction or supplemental answer to a questionnaire, if I may. Thank you.
You can, just a second, just get a little closer to the microphone if you can. Apparently people on the TV are having trouble hearing you.
Sure. I'm usually accused of the opposite problem, but I'll do my best. In answer to, I think it's question 18 on the Superior Court questionnaire, I was recently appointed as co-chair of the Committee on Artificial Intelligence, and the courts by Justice and Chief Court Administrator Alexander.
All right, thank you. Questions from the committee. We're going to start with Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I sit here in a strange position. Recently, the Supreme Court heard the case Amadassim versus Balboni. And I did watch that as a law nerd and not as a active participant. I have since now involved in that case, representing somebody who did not have a lawyer at that time in that case. I do expect that more than likely that matter will end up before the Supreme Court again for some reason. So I sit here, what should I do? Erring on the side of caution, I think it's best that I recuse myself from being part of this today. So I think that's the right move to make. So I just wanted to put that on the record, and I'll leave the room.
Yeah.
If that's
Further questions or comments from the committee? Let's give him a moment. We have a line here. Hold up. So, Justice Eckert, let's dig in a little bit. Obviously, AI is a big topic in the legal industry at this point. It is something that I think, you know, we're seeing from sort of all parts. You know, I certainly am seeing in my own practice where you've got certain pro se litigants who are popping something. You know, I filed them. I filed a motion to strike probably 3 weeks ago, and probably a 15-page motion to strike, 18-page motion to strike, and served it on the pro se on the other side, and 45 minutes later got a response back. Maybe the person is a quicker drafter than I am or any of my team of associates are, but be that as it may, we got the response back within 45 minutes, and some of the points made, I think were potentially on point. Some of them seem to stray a little afield. But we're also seeing the opposite extreme. We're also seeing, I think, most of the AmLaw 100 firms, even some of the larger law firms now in Connecticut are starting to invest in products like Harvey and some of the real sophisticated kind of legal AI tools that are out there for analysis. And I'll be honest, it's changed my practice in a number of ways. So talk to me about what you're seeing, what you think the branch is seeing on AI, and maybe some tips that this legislature and this Judiciary Committee in particular should be thinking about kind of as we grapple with the new technology and the pros and cons of it.
Yeah, great. With the caveat that I'm just sort of learning myself, it was a reappointment, and there's a lot to think about, a lot to learn, a lot of materials out there, and some courts have taken steps. My guess is legislatures and other policymakers as well. In the judicial department, I think there are probably three areas of particular concern. One is briefs, motion, the kind of thing you were talking about, briefs, motions, that kind of thing, hallucinated cases, or otherwise unverified or unreliable propositions that appear suddenly in papers. So that's one issue, and I think at least tentatively that we're letting the Rules Committee handle that under Justice Bright's oversight. There's a proposal now. I think it's public, but if it's not, it certainly soon will be. I don't think there's anything confidential about it, to handle it by way of a certification process of some kind. That is, so that the lawyer, the pro se, whomever is filing the papers, has to certify that they've verified the information and it's accurate, as opposed to, for example, a bar, which seems unrealistic. anyway, that's in the works. We just had this week a motion for sanctions filed in our court, the very first one that I've seen, claiming that the other side in a case in front of us has used AI and generated false cases. So we're dealing with that as a court. The other area that's, I think, really hard to deal with is evidence, because the problem with AI, as I've learned, and I think as we all know, is you just don't know what's true anymore. It further plunges us into this world where it's very difficult to distinguish fact from fiction. So that issue is being handled by the evidence committee, I think, in the first instance. You can see I'm really good at delegating, but because I'm not sure what's left for the AI committee, but it's appropriately with the evidence committee. That's going to be very hard, very, very difficult to determine how you authenticate, evidence of any kind. And we've all seen what AI can do in that regard. And then the third area, which I think we're going to be paying attention to with the help of the IT folks, is more internal to judicial, administrative, something I'm not particularly an expert in. Those are the three areas, and I'm not sure the legislative role in terms of your question on that, but certainly it's a societal problem in many, many ways. Economics of it are potentially drastic, and so forth and so on.
Let me ask you a little bit about, I think sometimes, how do I put this? I think I've noticed on certain occasions you tend to be kind of a dissenting voice on the court. And I don't mean that in a negative way. I think it's refreshing. I think, it's important that just like we have in the legislature, that there's open debate and dialogue, and you have a majority and you have a minority, and it's just as important that the minority gets their point out there as the majority sometimes. But I want to talk to you about, I think it's a case that's closed, and I probably can appropriately ask you about, is the fatal police pursuit case in Seymour. And I think you issued a dissenting opinion in that case, if I recall, that might have pushed your colleagues a little bit on their interpretation of statutes that we in this committee sort of authored. And I think to paraphrase, and correct me if I'm wrong, but I think you sort of said the majority was probably straying from what the majority will of this committee was, kind of on that topic. And I'd ask you just to sort of maybe not dive into the details of that case, but just talk to me about your judicial philosophy, your thought process in when to dissent, and why you believe that's important on the court.
Well, in terms of the general question, I don't want to be the dissenter, or known as the dissenter, or I think I answered one of the questions on the questionnaire saying what I believe, which is it's very important, if we can, to reach consensus on the court for a whole bunch of reasons. And I think we all really try to do that. My colleagues, I know, are people keep an open mind and try to reach a common ground. Sometimes that's not possible, and so the decision has to be made about when it's worth speaking up. And I think one has to really be careful and try to only do that in cases that matter, where your conscience tells you, I just can't sign that, So I do endeavor to do that. But there are some situations in which I just think that the majority gets it wrong. It's nice that over my tenure, anyway, we've always been pretty, it doesn't get personal, which is really nice. And I think there's a lot of respect going both ways. I hope if you read the dissents that you'd find that, and so forth. some of the dissents probably go into an abyss and nobody ever sees them again. I think it's the Borelli case that you were talking about. Every once in a while, something sticks, and I paid some real. I worked hard on that because I thought that the idea that police, even their emergency capacity, shouldn't have blanket immunity. If there was a violation, I mean, the statute itself, as I recall, requires a reasonable care. It actually says that in there. While pursuing, you can go over the speed limit and do all kinds of things that a normal driver can't do, but you have to be careful. And my understanding of both the legislative intent as well as the other indemnification statutes and so forth was that those cases shouldn't be barred as a matter of law from being brought. And Chief Justice Robinson, actually, we had some great discussions. I think he sort of, I would say, came around, but he and I had some good discussions on that. And I think over the course of a couple cases, got to the point where I think that was pretty much a majority holding. I think we were helped along. I'm sorry, I'm a little vague on the details, but I think we were helped along a little bit by a statute passed by this august body, which made it clear there may have been a dissent. I'm sorry, a veto, the first time through by Governor Lamont, and I think it was enacted after that. So that's the system, as far as I'm concerned. Sort of.
Yeah, I gotta ask you to get a little, maybe move that microphone closer to you. We're still getting kind of complaints about
Apologize.
hearing you. Yeah,
How's that?
much better. Thank
Okay.
you.
I'm sorry.
All right. Further questions or comments from the committee? Representative Blumenthal.
Thank you, Mr. Chair, and thank you, Justice Ecker, for being with us today. And as sometimes he does, the good chair's question spurred one in my mind. I think one of the reasons why we're seeing so many concerns or issues around AI and briefing, in addition to the fact that sometimes lawyers are less scrupulous and diligent than they should be, is I think that more and more there's a very high reliance on case law and argument from authority in our legal and judicial system generally. And I've seen, different kinds of judges, some, and this is a vast oversimplification, some especially on the lower court, see their role as trying to explore the law within the bounds set by precedent. Nobody should be violating or disregarding precedent. But some seem sometimes to be reading the tea leaves for what an appellate court might find in the future or signaled where it might be going. And I was curious, as someone who served at multiple levels of our judiciary, how you think about those issues and the development of our law.
Well, I mean, one of the problems is that there's such I don't know if it's a problem, it's just a phenomenon. There's such a proliferation of case law, not just in Connecticut, but through the entire country, but with every single thought of a judge now being published on Westlaw, you can basically find a case to support any proposition, if you look hard enough. It may be from Guam or the Eastern District of, wherever, but you could find it. So that causes a problem for trial judges, for lawyers, because what is the law? So I do find that there's a straying in that sense. There's also what I find to be a sort of a straying maybe over emphasis on case law in the sense that, if we're looking at a statute, the statute says what the statute says, and these things, just by the very nature of things, I'm not pointing any fingers, it happens that there's the statutory language gets encrusted with judicial language, and pretty soon everybody's talking about the judicial doctrine rather than the language of the statute. And you can get pretty far away from the statute if you're only looking at case law. So I see it happening there. I think it's something that just judges, and especially higher court judges, have to be constantly attentive to, particularly in cases of legislation, statutory interpretation, and application. I don't know if that answers your question.
It did, and I especially appreciated your answer about statutory interpretation and language. So thank you, Mr. Justice, and thank you, Mr. Chair.
Further questions or comments? Representative Osborne.
Thank you, Mr. Chair, and good morning, and thank you so much, Your Honor, for being here. And I appreciate the opportunity to speak with you and ask you questions this morning. Specifically, I'm looking at your questionnaire and I'm focusing in on question number 6 and your answer to that. And certainly, you know, the question is about, you know, Supreme Court decisions, U.S. Supreme Court decisions, what was right, what was wrong. And I fully acknowledge it. You know, we now have centuries of decisions to take a look at. And certainly your answer was not meant to be exhaustive regarding the decisions that you may not have agreed with. But I did note of particular interest to me, you noted one recent case that you thought was open to fair criticism. And again, understanding that this is not an exhaustive reply, and I completely understand that. But other recent cases that come to mind for me, specifically, particularly around the issue of precedent and following it or not following it, is the Dobbs versus Jackson decision. And I note that that's not one of the cases you chose to point out any disagreement with it. So I just wanted to get your thoughts on Dobbs, whether you thought was correctly or incorrectly decided, and particularly your thoughts about it in the context of precedent and what that means for the bench. Thank you.
Thank you. And no, I realized that the answer was certainly incomplete. And the first bunch of cases I chose were sort of low hanging fruit. It's hard to argue with. I ventured out a little bit with the one case, but you know, I was hesitant for the same reason I'm a little hesitant in answering your question, which is, I don't know the extent to which an issue like that or the application of Dobbs in state law would come to our court. I think probably it would go to federal court. Sometimes we get questions certified. I just don't want to get myself in a situation where I'm, you know, taking a position or giving thoughts on something that may come before us. So that's a little difficult. Also, to the extent that, I mean, it's really a hot button issue, you know, and there's so much, aside from the legal analysis, there's so much policy, I guess I'll call it. That's a bad word, but for this, because it's much deeper than policy for everybody, I think, no matter what your position. So that's another reason I sort of hesitate to give my views. I don't want to be evasive. I really don't. And, you know, but I also want to be careful not to comment on things I shouldn't be commenting on. The stare decisis aspect of the case, you know, it's right there. And it's also in Citizens United, by the way, which overruled a bunch of precedent. And, you know, if stare decisis is a doctrine that is applicable unless it's not applicable, you know, it's a matter of convenience, then it's not much of a doctrine at all. I'm not accusing the Supreme Court of doing that, picking and choosing. And sometimes, you know, I would vote to overrule cases. We have overruled cases in the last 8 years. So it happens. But we have to be careful. And there's numerous times when I've written concurrences where I've said, look, I really don't like the X case. I've done it a couple times. I don't think it was a great decision, but it's our law and we're stuck with it. You know, that's a roundabout answer with no center to it. And I apologize for that. If I'm going as far as I feel comfortable going on the Dobbs case in particular, but I understand why it's a matter of great concern.
Well, I really appreciate your answer. And I know that Dobbs obviously has been the source of a flood of legislation before this body. So I completely understand your concerns and I appreciate both your candor and your reticence to comment further on it. And I really appreciate the opportunity to ask that question, especially about stare decisis. So thank you so very much. Thank you, Mr. Chair.
Senator Kissel.
Thank you very much, Mr. Chair. Judge Ecker, congratulations on your renomination. I'm sure you're going to sail through the system with no problems. And thank Governor Lamont for all his renominations. He's done a great job. I'm interested about the questions that preceded regarding your interpretation of how, or your judicial philosophy. And one of the things that always interested me as a legislator is that the role of a legislative history. And so occasionally in the past, when I was at my desk practicing law, I would find a moment of time and I say, I wonder if I'm named in any cases. Go into like the Westlaw database and like, amazingly, like things would pop up. And it seems to be something that ebbs and flows. And sometimes I found a slew of cases where I hardly remembered being at the forefront of that debate. It was like the second injury fund. But it seems like something that, again, ebbs and flows, and some judges seem to avail themselves of it, and then some do not. We've had debates on the floor of the Senate regarding what we were saying, and I've had people, colleagues say, what we say here doesn't matter at all. It's really the black letter of whatever is on paper. And what we're saying here between us, and then I hear other folks that say the exact opposite, say the colloquy can help put meat on the bones and help flush out exactly what our intent is as a legislature, the purpose, and that it is actually extraordinarily helpful. And I remember it was actually pretty, and I'm not trying to throw them under the bus, but during one of those debates, where it was a rigorous discussion because I think they were just trying to shut me up in the Senate. And, but I said, hey, listen, because I also serve on regulations review. I said, say what you will, but a lot of times we look to legislative history to help inform our decisions when a department or an area of the government creates regulations. And out of the blue, my former caucus leader, now Judge Kevin Kelly, said, absolutely. We just, I just was looking at legislative history for a case that was before me 2 days ago. And of course that has an important bearing. Now, whether that's because he had a history of moving up through the legislature, I don't know. So I'm just wondering what your take is on what we do here in our debates and whether it's in committee work or it's on the floor of the House or the Senate. And so that we can be better informed as we march forward. Are we doing a great job of setting up legislative history? Is it useless? What's your take on that?
To answer that question, I think I have to mention 1-2Z because it's sort of the elephant in the room, if you will. Not necessarily in a bad way. It is what it is, but it's taken very seriously, at least on our court. And everybody tries to apply it. I think different people have different personal views about whether it's a net good or bad. I have complicated views. I'm not sure, but there's other issues sort of floating around, but we apply it. It's good law and we apply it. And I think everyone tries to. So that, that statute says we just can't pay attention to legislative history or anything like it if the language is clear and unambiguous, right? So I don't think that the statute in any way really accomplished its purpose, which was to end that battle over the meaning of a statute and force us to just deal with the text, because now the whole fight is over whether something's ambiguous or not, and we spend just as much time fighting over, well, I don't, bank could mean a couple different things or whatever, so I'm not sure it's really change that, but it does change practices. And once it's unambiguous, there is no further delving. it's sort of from what you said to me just now, which is fascinating. It's sort of maybe an unintended consequence of 1-2Z is that it may make some of the work that you all do here irrelevant, if it's behind the scenes, you know. But I think that if there's, look, a statute just can't contemplate all applications in all situations. And so even if it's not in vacuo, you know, ambiguous, it can easily become ambiguous as applied to facts of a case. And so legislative history still matters, certainly for that purpose. And it's consulted and very, very helpful in resolving close calls. That's what I find.
No, I find that answer really helpful and informative. And I'm not looking to justify deliberative battles that we have on the floor of the Senate or the House. I've been blessed by my constituents and extraordinarily lucky to do something that I find highly fulfilling, and that's to be a state senator. And I've been lucky enough to do it now come February 23rd, because my first race was a special election, to have been doing this for 34 years. I remember when we in the Senate in particular found a decision that we thought was completely upside down and backwards. And that's when your colleague, now Justice McDonald, and I was there, came up with we mean what we say and we say what we mean. And then we passed that. Now the battle is over what is ambiguous and what's not. So I'll have to target those things that are in our proposed legislation that may be ambiguous if we're going to flesh that out. But, you know, it actually keeps our feet to the fire a little bit as well, because we don't want the statutes that we pass to be ambiguous. We want them to be as clear as possible. So I think it actually has done good, but it's also heartening to know that you folks across the street are still digging through just down the hall in the state library, maybe what was written or what the transcripts of what was stated in debates regarding the bills. And there are certainly pieces of legislation where my staff, Attorney Dykes is here in the room, does an awesome job, where we will comb through the bills that come before us for possible passage, and we will spot what we think is maybe a gray area. And sometimes there's just no words that can make it any better than it is in a succinct manner. And the debate that takes place on the floor of the Senate is extremely helpful, or we're trying to be helpful. And sometimes, you know, for example, in the Senate, I'll have the good chair, Senator Winfield, and we'll say, let's try to make this clear by a discussion between the two of us. And then we do that in a amicable fashion. We're actually, it's not an act, but we're trying to help anybody that bumps into that statute down the road in a litigious confrontation. So I appreciate that. Again, best of luck in the future. Having worked with Senator Looney for so many years, and my former legislative aide, Kate McAvoy, formerly Kate O'Keefe, daughter of Judge O'Keefe, I understand that whole New Haven thing. And it's okay to still love New Haven, because so many darn judges come out of that area. It's amazing. But I wish you the very best of luck. Thank you very much, Mr. Chair.
Further questions or comments from the committee? Further questions or comments? If not, just Secker, good seeing you. Congratulations on your renomination. Thanks for being with us this morning. All right, next, we will turn to the nomination to be a judge of the appellate court, the Honorable Ingrid Mall of West Hartford. Okay. Judge Mall, I'm gonna swear you in. If you may raise your hand. Do you swear or affirm as the case may be the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? Great. Have a seat. The record will note that Attorney Blumenthal is going to recuse himself. Maybe you can tell Attorney Fishbein he can come back into the room. And then we'll get started. One of the joys of a part-time legislature. Some days it feels more full-time. All right, Representative Fishbein is back, and Judge Mall, whenever you're ready, we'll hear your opening statement.
All right. if I could, Representative Fishbein appeared in front of me twice yesterday. So he indicated earlier to me in
All
this
right.
room that he intended to recuse himself. I don't mean to step over his toes.
So just for the public, if folks are interested, obviously we do have a part-time legislature, particularly on the Judiciary Committee. There are certain members, certain of us who have active practices of law and appear regularly in our state courts. The rule that is generally followed is where a attorney legislator has a pending matter before a judge, either they have a case that is individually calendared to that judge, or that judge has an open decision they're waiting on. So maybe it's not an individually calendared case, but they argued a motion for summary judgment and it's within the 120 days and you're waiting on a rule, then that legislator will recuse. That's the basis for recusal, in case anybody was asking, because it may happen a few times today. With the Supreme or the Appellate Court, obviously, if somebody has a case before the Supreme Court, then they'll recuse for any justice of the Supreme Court, or if they have a case before a particular panel of the Appellate Court, they'll recuse. With that, back to you, Judge Mull,
Okay, thank you.
who I do not currently have a case before. But plenty when you were when you were a Superior Court judge, but not lately. So go ahead.
Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, and distinguished members of the Judiciary Committee. I am deeply grateful for the opportunity to appear before you today. I would like to extend my thanks to Governor Lamont for his confidence in nominating me to be a judge of the Appellate Court for a second term. It has been my privilege to serve as a judge for the past 12 years. I first served as a Superior Court judge for 2 years in the criminal courts of Waterbury and New Britain. Then, for the 2 years that followed, as a Superior Court judge assigned to one of the complex litigation dockets in Hartford, which included a consolidated products liability docket, then comprising over 2,300 individual products liability cases. In 2018, I was nominated by Governor Malloy to the Appellate Court, where I have served for the past almost 8 years. Becoming a judge, and particularly an appellate judge, had been my dream since I served as a law clerk 26 years ago to the late Justice David Borden when he sat on our state Supreme Court. I could not have asked for a better role model or mentor, and I have endeavored to serve the people of the state of Connecticut and all those who access our courts with those attributes that he modeled, like diligence, respect, integrity, and fairness. In addition to my assignments as a trial judge and my appointment as an appellate court judge, I have been a member of many judicial branch committees, which are all listed in my submission. I have been a co-chair of the Access to Justice Commission and a judicial branch representative on the task force to improve access to legal counsel in civil matters. Currently, I serve as the chair of the Client Security Fund Committee and the co-chair of the Advisory Committee on Appellate Rules. Outside of the courthouse, I have endeavored, so long as my court schedule would allow, to accept the frequent invitations to speak to people, young and old, on various topics involving the judiciary and the rule of law, and to judge various competitions from middle school mock trials to high school essay contests to law school moot court competitions and mock trials. Serving as a Superior Court and Appellate Court judge has been the greatest honor of my professional life, and it is my great desire to be reappointed for another 8-year term. Thank you again for the opportunity to be here today, and I would be pleased to answer any questions that you may have.
Questions from the committee? I believe Representative O'Day is online. Representative O'Day, I know he's feeling a little under the weather. We hope you feel better soon, Representative O'Day.
Thank you very much, Mr. Chair, and good morning, Your Honor. I apologize for not being there in person. I'm a little under the weather, but I want to thank you for your service. Going through, I was happy to see that when we first met when I was a trial lawyer on the Badger case, and you listed that as one of your more memorable cases, significant cases. I just want to congratulate you and thank you for your years of dedication and service. Your parents were constituents of mine way back when. I know you lost both of them this last year, and I'm so sorry for that.
Thank
But I know they're very proud of you, and you've been an amazing public servant, and I wish you all the best and good luck going forward. And thank you.
Thank you very much for that.
Judge Mull, let me ask, I mentioned, obviously, I had the pleasure of appearing before you when you were on the complex litigation docket in Hartford for those years. How has the transition away from sort of a strictly civil caseload and particularly kind of higher impact, higher leverage kind of commercial cases to maybe a little bit more of a general practice that the appellate court sometimes can be? How have you enjoyed that? What challenges have you faced?
Yeah, when I first became a judge, I of course sat in the GA for 2 years, and that's quite an education coming from a complex business litigation background as a practicing lawyer. So I certainly got a taste of the more high, volume dockets. But to answer specifically your question, I've enjoyed the variety of cases very much at the appellate court. We, of course, get appeals from every division of our Superior Court, so civil, criminal, juvenile, and family. The variety has been very interesting. And when every day presents something new to learn, that makes the job all the more enjoyable. I've been there now for 8 years, but very often there are still new issues to learn. And I've enjoyed it a lot. I mean, my comfort zone probably remains the complex, civil cases. That's what I kind of grew up in as a lawyer. But the variety is very interesting, and kind of every day is CLE, really.
You mentioned the Access to Justice Commission, and obviously access to justice is an issue that comes before this body every single year, and probably we don't have a hearing in this committee that access to justice issues aren't front and center. What do you see as sort of the biggest challenges facing the branch right now when it comes to access to justice?
The number of self-represented parties has been a surprise to me, frankly, not just at the trial level, but at the appellate level. That presents certain challenges to the branch, not only from an administrative perspective, but also in the development of the law. So I'll throw out a statistic that I became aware of a few years ago, just from the appellate side, that I think the number is around 40%. I might be off a couple percentage points, but in roughly 40% of every appeal that's filed, there's at least one self-represented party. That's, to me, just a gigantic number. And so what we see, and again, I'm speaking as an appellate judge now, if I could, is that the self-represented party might have meritorious claims, but they were never raised below. Or they haven't been presented on appeal in a manner that's, adequate. Or so that ties our hands, because as judges, we're an advocate for no one. So the lack of representation, I think, continues to be an ongoing problem. It's, of course, a money problem, right? I'm sure you face these questions all the time in terms of, are there areas where statutorily you could create a right to a lawyer? And, but that costs money, which I appreciate. So I've identified a problem that you're already aware of, but the solution I'm not sure of.
No, and that's fair. I think if any of us had the solution, we probably would have done it by now or tried to. I guess maybe just to push a little bit though, at the Superior Court level, a pro se is not going to get their motion for summary judgment bounced because the font is the wrong style, or the footnotes are 15-point font instead of, I don't even know, the pellet 12-point font. How do we make, how do we make it so that a pro se, maybe the process isn't quite as intimidating when you get to that appellate court level? Is that something the court is focused on? Is that an issue you're looking at? Please.
Yeah, just where you began in terms of, briefs getting kicked because they don't strictly comply with the rules. I think our clerk's office has done a very good job in maybe reading broadly the rules and allowing perhaps more briefs than would be permitted under a strict application of the rules in terms of font and those things that you mentioned. And I know they're flooded with, phone calls and inquiries and how do I do this? How do I do that? I think my understanding is that they do a very good job with interacting with the public and self-represented parties. We, of course, in our state law have a principle that we do give some leeway to self-represented parties, but only if it does not prejudice the other party. And that is a principle that's been well settled under our state Supreme Court precedent for some time. And so we're, bound by that.
But is that a rule change the appellate court is looking at? I mean, if a pro se files a brief where the footnotes are 14-point font instead of 12, that doesn't prejudice the other side. I mean,
I think that would probably be permitted. I mean, oftentimes I'll read an appellate brief and I think, how in the world did this get accepted? Because it doesn't look like other briefs, but it does get accepted. And I think if some of those briefs on the edges did not get accepted, the system probably would have a lot more strain in terms of kicking things back and going back and forth. I mean, obviously there's a lot of inefficiency and frustration that would occur because of that.
all right, fair enough. Thank you. Further questions or comments from the committee? Further questions or comments? If not, Mr. Small, congratulations on your renomination. Thanks for
Thank
being
you.
with us this morning. All right, we are going to turn our attention to the nominations for the Superior Court. These are all renominations. We are going to start slightly out of order just because of a pre-existing issue that we had worked through with the branch. So we're going to start with Lisa Egan of New Haven. Judge Egan, if you could raise your right hand for me. Do you swear or affirm as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. Have a seat and whenever you're ready.
Good morning, Chairman Senator Winfield and Representative Staffstrom, ranking members Senator Kissel and Representative Fishbein, vice chairs and other distinguished members of the Judiciary Committee. I am Lisa Grasso Egan, and it is a pleasure and honor to be before you today for your reconsideration of my reappointment to a second term as a Superior Court judge. I stand corrected, your consideration. I also want to thank Governor Lamont for nominating me to continue as a judge of the Superior Court. I have found the experience as a judge deeply fulfilling and enriching, and I would be honored to continue to serve. I began my service 8 years ago, assigned to the Stanford Judicial District, which included the criminal, civil, and family dockets. In September 2018, I was assigned to the family dockets, where I have continued to serve. I first served in the Bridgeport Judicial District for 4 years, followed by the New Haven Judicial District, where I am now in my 4th year. During my term, I have presided over numerous trials and hearings, and I've had the opportunity and pleasure to work with numerous parties and attorneys to help resolve their disputes through a negotiated resolution. I serve as vice chair of the branch's Law Library Advisory Committee. I regularly volunteer with Read Across America, and I have participated as a judge in moot court competition for Quinnipiac University. I am an adjunct professor at the University of New Haven, teaching family law, and I remain active as an alum and an alum mother of 2 daughters for our high school. I consider it a privilege to serve the people of the state as a Superior Court judge, I would be honored to be approved by this committee and continue in that role. And to that end, I welcome the opportunity to answer any questions you may have. Thank you.
Questions from the committee, Representative Fishbein.
Thank you. Good morning.
Good morning.
Congratulations on your renomination.
Thank you, sir.
Tell Pat I said hi.
I will.
Have a good
Thank
day.
you. Thank you so much.
Further questions or comments from the committee? Further questions or comments? Seeing none, thanks for being with us this morning.
Thank you so much.
Congratulations on your
Mr. Chair, I was just going to say, go Friars. Sorry, Your Honor.
Sorry, hold on. Representative O'Day?
No, I was just going to say, go Friars.
That's
Thank you
right.
very much, Mr. Chair.
Thank you.
We will try to hold that. We will try not to hold that against her.
Thank you.
All right. We will return to the call here, and next up will be the Honorable Barbara D. Aaron of Clinton. You got a fan club over here, Judge. If you could raise your right hand for me, do you swear or affirm as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? Great. Have a seat, and whenever you're ready.
Thank you.
Good morning, Senator Winfield, Representative Stastrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. Thank you for the opportunity to appear before you today to seek reappointment for my second term as a Superior Court judge. I also want to thank Governor Lamont for nominating me. It has been both an honor and the pinnacle of my legal career to serve as a judge in our great state. The responsibility of this role is both humbling and challenging. I strive to serve the public with integrity, patience, and independence, and to treat every person who appears before me with respect and dignity. I listen carefully, remain open-minded, and am willing to change my views based on the evidence and the law. Most of my service on the bench has been in the juvenile court, where the work requires balancing accountability with compassion and where my decisions can, and often do, profoundly affect children, families, and communities. I am mindful that many who appear before me have experienced significant trauma and that the courtroom is an unfamiliar and intimidating place. I make every effort to ensure that litigants feel heard and treated fairly, and to make even the most difficult decisions with clarity and humanity. I am fortunate to work alongside dedicated clerks and marshals, attorneys, court service officers, and colleagues who are deeply committed to public service. It is my sincere hope that you will approve my nomination and allow me to continue this work for another term. Thank you for your time and your consideration, and I'm happy to answer any questions you may have.
Thank you. Questions from the committee? Representative Osborne.
Thank you, Mr. Chair. Good morning, Judge Aaron. Lovely to see you, even if it's not at Starbucks. I just wanted to ask a quick question, and you were by far, one of the most respected family court attorneys at the time you took the bench, and you have served almost, or predominantly, I should say, in juvenile court since your appointment. And I personally think you would have a lot to offer the family bench. Can you give us any information about how your task assignment comes about? Because I'm very interested in having family court attorneys serve on the family bench. On the other hand, I know, having served in juvenile court, that there's a great need there as well. So I was just curious about your information on that. That's all. Thank you.
Thank you. And I appreciate that very much. We generally get to, at the end of the term, submit our preferences. And the branch, I think, I can't speak for them, but they first fulfill their needs, and then they try to accommodate as much as they possibly can what our preferences are. I will confess to you that as much as I love practicing family law and I still dabble in it, in many of my assignments, I have sat also in family, but I've been primarily in juvenile as the presiding judge. And I still am able and willing on occasion to do pretrials and judicial pretrials and mediation. But I have asked for juvenile. It has been my number one choice for the last number of years. And I can say that although initially I was assigned there and I was somewhat clueless, I was a rookie and a novice, but the more that I have sat in juvenile, the more I feel that I really can make a difference and be of service to the people of this state and people that otherwise oftentimes are sort of invisible and overlooked. And I've sort of really settled into and love the nature of the work and that's done there and the people that I work with. But thank you.
Well, thank you for your service and I'm sold. Thanks. Thank you, Mr. Chair.
Further questions or comments from the committee? Representative Robertson.
Good morning. Just a comment. One, I've learned about you for the past 24 hours. Somebody's been rambling about you. So thank you for what you do. It's a wonderful nonprofit in my community called Black Girls Get Legal Tea, where basically they help Black and brown kids go to college that want to be attorneys. And I heard that you are a big attribute to that founding of it. Hence my last name is Roberts. My sister is the AAG Attorney Roberts. So we heard all about you and everything that you've done within the Waterbury aspect and just helping those families, especially in the poverty areas. So thank you for what you do. Like I said, I'm a big mascot now. So congratulations early.
Thank you very much.
Further questions or comments from the committee? Further questions or comments? Check online. If not, thanks for being with us. Morning. Congratulations on your renomination.
Thank you very much.
All right. Again, I'm going to use a little prerogative here. Given a family situation, we're going to take Judge Courtney Chaplin of Hartford next, please. Judge Chaplin, if you could raise your right hand for me. Do you swear or affirm, as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? I do. Great. Have a seat, and whenever you're ready, we'll take your opening statement.
Thank you. Good morning, Chairman Winfield and Establishment, ranking members Kissel and Fishbein, and esteemed members of the Judiciary Committee. I want to express my sincere gratitude to Governor Lamont and the Governor's Council for nominating me to continue serving the people of Connecticut as a Superior Court Judge. Thank you to the esteemed Judiciary Committee for the opportunity to discuss my qualifications today. Serving as a Superior Court Judge has proven to be more rewarding than I could have ever imagined. I've thoroughly enjoyed this incredible journey, knowing there's a new and exciting challenge around every corner. I began my judicial career handling GA criminal matters in the New Britain Judicial District. I was then assigned to handle juvenile matters in New Britain. Subsequently, I was reassigned to the Wyndham Judicial District, where I served as the criminal trial judge for GA and Part A matters. Concurrently, I served as the trial judge for Willimantic juvenile matters. Next, I was assigned to preside over habeas corpus trials in the Talon Judicial District. While presiding over habeas trials, the world shut down. When the court slowly began reopening, I covered criminal matters in the Hartford Judicial District. As the courts fully reopened, I was assigned to preside over civil matters in the Talon Judicial District. During that period, I was concurrently assigned to serve as the acting presiding judge for Willimantic juvenile matters. Following that, I was assigned to the Wyndham Judicial District as a criminal trial judge for GA and Part A matters and also assigned to handle Willimantic juvenile matters. During that time, I also covered New Haven juvenile matters periodically. I then served as the presiding judge in the Meriden Judicial District and GA Court. Although primarily a criminal assignment, I also handled family, civil, and housing matters. I then served as the presiding judge for GA matters in the Hartford Judicial District for 2 years. That assignment consisted of handling judicial pretrials, the gun docket, and a wide variety of pretrial and post-judgment motions. Currently, I serve as a trial judge for Part A matters in the Hartford Judicial District. In addition to my assignments, I've been able to serve in a variety of leadership roles, including serving on the Superior Court Rules Committee, the Sentencing Commission, the Judicial Media Committee, the Investigatory Grand Jury Panel, a faculty member for Civics Academy, and co-chair of the Connecticut Advisory for the Advisory Council for the Victims of Crime. In the community, I serve as a board member of Lawyers Concerned for Lawyers, a bench for the Oliver Ellsworth Annual Court, past president of the Beta Sigma Lambda Chapter Alpha Phi Alpha Fraternity Incorporated, chairman of the Deacon Board of Shiloh Baptist Church here in Hartford, and adjunct instructor at the University of Connecticut School of Law. Each day I touch countless lives through the decisions I make. I remain cognizant of the practical realities, how each case impacts the everyday lives of real people in our community. Thank you for taking the time to review my materials and consider my qualifications, and I welcome any questions you may have at this time. Thank you.
Questions or comments from the committee? Questions or comments? Yeah, Representative Roberts.
Thank you for what you do, good brother. What you forgot to say, you became the youngest Superior Court judge as well in Connecticut. That's a big thing. Thank you for what you do. Shout out to the brotherhood as well. And just keep going. Keep going.
Thank you.
Further questions or comments? If not, congratulations. Thanks
Thank you.
for being with us. this
My
morning.
pleasure. Have a great day.
All right. Judge Bail will be next. Claudia Bail of Rocky Hill. He was 8. I don't know if you could raise your right hand for me. Do you swear or affirm, as the case may be, the information provided this committee be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury? Great. Have a seat and whenever you're ready.
Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, Vice Chairs, and all distinguished members of this Judiciary Committee. I'm Claudia Bayo, and I thank you for allowing me this opportunity to appear before you today and for considering my nomination for reappointment for a second term to continue to serve as a judge of the Superior Court. I also thank Governor Lamont for nominating me for reappointment and Governor Malloy, who initially nominated me in 2018. It has been an incredible honor to serve the state of Connecticut in this role, and an honor and responsibility that I work hard to live up to. During the past 8 years of my first term, my assignments have been first to Hartford Criminal Court, where I presided over the domestic violence docket and the GA trial docket. Then as the presiding judge of housing in New Haven and Waterbury, and then Hartford and New Britain, followed by Hartford Civil, New Haven Criminal, where again I handled the domestic violence docket, and Hartford Civil again. I'm currently assigned to the Hartford Civil docket and the land use docket, and I've handled foreclosure dockets both in New Haven and in Hartford, including currently. I've served and continue to serve on the Judicial Branch Executive Committee, the Civil Jury Instructions Committee, and as a chair of the Judicial Branch Bench Bar Foreclosure Committee. I'm a Connecticut Bar Foundation James Cooper Fellow and on a number of committees there, and a member and past president of the Oliver Ellsworth Inn of Court, for which I'm currently serving on the Executive Committee, and I'm also on the committee for the national organization, the American Inns of Court. Outside of the court and bench bar activities, I participate in various volunteer activities as well. Read Across America program, the Judicial Branch Civics Academy, as a volunteer in the high school mock trial program and at Hartford Public High School, and in mentorship and leadership initiatives at Trinity College and Quinnipiac University. I also teach as an adjunct instructor at the University of Connecticut School of Law, and I'm involved in my local community as well. I am hopeful that my record will provide this committee with the confidence that I understand, appreciate, and am committed to the hard work and the responsibilities of this position, and to vote favorably on my reappointment to allow me to continue that honor of serving, a vote that I would be most grateful for. At this time, I'm happy to answer any questions that you may have.
All right. Well, somebody decided to turn my microphone off for the rest of the day, so that's going to be an issue. But questions from the committee. Representative Fishbein.
Taking me 8 terms to figure out how to do that to you. Anyway.
You're probably not the only one happy about it. Go ahead.
Congratulations on your renomination.
Thank you.
It appears, looking at the backup, that you've never sat in family. Is there a reason for that?
I have no idea. I would like to think that the record of the assignments that I've had have shown that I clearly mean it when I say I'll go wherever I'm assigned. I haven't been assigned to family. I did just during the COVID time when we were covering, during the period of time when the court was not actively in session. I covered in Waterbury on occasion, but other than those limited periods of time where I covered in the Waterbury family. I've not been assigned there, and I can't tell you why.
Okay. And then, you did humbly admit that, housing cases can be emotionally draining. Um, and I thank you for the admission. What do you do? I mean, as a judge personally, when, you're in the middle of a housing matter, which usually involves at least one pro se, and you find it to be emotionally draining? Do you have some sort of resource or some sort of outlet? Go in chambers and scream? Or, I mean, how do you
So-
handle that?
That's a great question. The housing docket can be particularly challenging, and in particular during the period of time of the COVID years where I was in New Haven and Waterbury. But it's challenging in any event. And there are times where if I feel that there's a need for me to take a step back, I will take a recess. I'll take a break, both for the benefit of the people in front of me and for my own ability to be able to ground myself again and do what I need to do in the courtroom. There are times when the trial's concluded and I just need time to absorb and take the time that's necessary. So it might mean taking it home emotionally with me. Back in New Haven, where our chief housing court clerk sits, there have been occasions where he has seen the drain sometimes, and it's not just me. I know it's whoever sits in the dedicated housing courts. And there are other courts that have their own challenges, but housing does carry a number of them. And he's referred, I think, appropriately to it as, and said to me, you're wearing the weight of the robe. And it is that weight that it's hard to balance, but it's our job to do. I don't know if that answered the question, but
No, because you're exuding caring. So I think you did answer the question. Because a lot of times we talk, especially with first nominations, about outlets and how you deal with stress and that kind of stuff. So, when I saw it in the backup, I was like, okay, well, that's right. You did indicate that there was an occasion where you were late on issuing a decision over the 121-day deadline. And I couldn't tell from the backup what kind of a case that was or any of the factual scenario, because certainly we need people to have faith in the process.
yes.
And, when I tell a client, okay, we've concluded the trial, but the judge is 120 days, it's my word, right? So I'm very concerned when I see, and there's only one, because there's others here that have more than one. Can you give us a little bit more
Absolutely.
information?
Because it was one that I was completely dismayed about, and it was not a substantive matter. So as I know you're familiar with, there are matters that are marked take papers and heard on the papers, and those are usually things like motions for default, motions for continuance, a discovery dispute, something that is not substantive to the point where there's going to be oral argument. I have never been late on any other decision other than there was one take papers matter that happened during my term when I just was assigned to Hartford Civil Court. Different courts run their procedural process differently. And I had completed all of my take papers assignments. There was one that I did not know was assigned to me because I was not familiar with how the process was. I thought I was, but I wasn't familiar with how that came in. I found out on the morning of the 121st day that there was one matter that was a take papers matter. It was a non-substantive matter, and I immediately addressed it. I considered it, and I entered the order on the morning of the 121st day.
I got that from the backup, but what kind of a matter was it? I mean, usually TPs, because I was a clerk, while I was in law school and all of that stuff, and I was the guy who put the TPs on the judge's desk. As you said, most of them are default motions or something innocuous. The only way I would get into a 120-day case is where, it's a motion to strike or motion to dismiss and both parties waived oral argument,
Right.
right? Then it becomes a TP. So what kind of a matter was this?
it was a civil matter and it was, I can't recall whether it was a motion for default or a continuance, but it was something that if I had just seen it, it would have been a no-brainer to be able to address it. It was an uncontested procedural motion that was on the calendar.
So I'm just trying to, and
Do you want to know how I didn't know about it? Is that?
yeah, I mean, because usually there's a stack of files on the judge's
Yeah.
desk and, you know, these are the TPs. So, yeah.
I can answer that. So because my assignments have been civil, but have also, when I've been in the civil assignment, I've also handled the foreclosure docket. Those are handled separately. My short calendar, I have 2 short calendars. And so my first short calendar in Hartford was handled differently than it was when I was in New Haven. And so the short calendar, instead of having all of my take papers together, I was given an assignment list of all of my, what I thought was all of my take papers, but they were all foreclosure take papers. There was apparently a civil take papers marking that was not sent to me, and I didn't know it existed until the 121st day in the morning, at which point I had wished that it had brought to my attention on the 120th day so that I could have gotten it in time, but it wasn't. And that was how that happened.
Okay. I thank you for your explanation. And once again, congratulations on your renomination. Thank you, Mr. Chairman.
Judge, let me just follow up. This is just more general curiosity than sort of with respect necessarily to your nomination, but the 120-day rule, I actually think it's one of the real advantages of our state court system vis-a-vis being in federal court, because as a practitioner, you can tell a client, look, you're likely to get or you're going to get a decision by X date, as opposed to in the federal system where frankly it could 6 months, 8 months, they got a lifetime appointment and there's no clock, and whatever happens. You get a decision when they feel like it. But I think I've noticed sort of just anecdotally lately, I feel like more decisions, I feel like it's taking judges closer towards that 120th day than I feel like I've been used to in the past. And I know we're not necessarily over flooded with civil cases or the docket filings are up, but I'm wondering sort of how you prioritize, because it does at least just seem to me that stuff that shouldn't take 120 days. Sometimes the drawback of the 120-day rule is stuff that shouldn't take 120 days. Sometimes judges, I think, sort of wait and I'll get to that, 3 months from now, kind of when we get there. And I'm wondering kind of how that process plays out and how you triage cases.
Well, I can only speak to
Yeah,
my own
yeah.
experience. So I will tell you that the 120 days seemed like a really long time when I was on the other side of the bench. And it seems to go by a lot faster when you're sitting on the bench, just because of the number of responsibilities that there are in addition to having to write decisions. But my practice is generally, if I can render a decision quickly, if it's something that isn't going to take as long of an amount of time, there's not an issue that needs to be extensively researched. It's something that I feel that I can address in a relatively short order. I try to get those decisions out as soon as possible for that very reason. Number one, it's better for the people who are waiting for the decisions. And it also helps to prioritize by taking those cases that can be addressed quickly and having them finalized and out. It's the cases that come before, again, I can only speak to myself, although I would imagine it's probably the same for some others. The cases that involve either cases of first impression or cases that involve significant issues that require a lot of research and time. Or for instance, now that I'm sitting half of my time on the land use docket, those cases take longer because there's extensive records and a lot of issues that need to, regulations that have to be reviewed and law in those particular areas, they take longer. And so those, even if you start them, and again, unfortunately, there aren't a number of consecutive writing days because there's other business that needs to be conducted. So I may start that, but then I have to put it aside because there's another matter that requires attention in a courtroom and then come back to it. And so those take longer.
Yeah, and you don't necessarily have to comment this, but one of the things sort of I've wondered over the last few years, and I've wondered aloud in this committee a couple times, is whether the 120-day rule needs to be tweaked. And by that, I mean, maybe it needs to be a little bit longer for a, land use appeal or for a summary judgment motion, but frankly, it shouldn't take 120 days to get a ruling on a discovery motion.
Right.
That should be dealt with in 30 days, 45 days. I mean, the entire case is delayed while you're waiting 120 days for a ruling on a discovery motion, or a motion to strike, really, most times shouldn't take 120 days. So I've often wondered sort of whether I think it's the right policy that sort of there's a deadline, but should we be looking at sort of a tiered deadline structure that certain motions should be decided quicker than 120 days and other stuff should be 100? Do you think something like that is workable, practical, or kind of given the workload, something like that's not really doable?
Again, given that I can only respond from my own experience, I can't really answer that from a system-wide response. I can
Fair
tell you
enough.
that I do think that it makes sense for us to have a deadline to submit decisions for the benefit of everybody and to keep the process going. And I agree with you with the way that you have mentioned the prioritization of the types of matters that don't take as long. At least in my experience, that has been true.
Great. Thanks so much. Senator Winfield.
Thank you, Mr. Chair. And I just want to, you touched on something with Representative Fishbein. I just want to pause there for a second and thank you for thinking about and operating in a way that you have an outlet. I've been on this committee long enough to have seen some of your now former colleagues who had a bad day. But they didn't have a bad day. They had a bad series of days and didn't know how to deal with those things. And those explosions in the court were problematic, particularly for folks who are in front of someone who doesn't understand all the rules of the court, the pro ses, right? The conversation that happened a little bit earlier about font to some people sounds like an absolutely ridiculous conversation. To them, it sounds like, what I'm trying to do. Why can't we just do what we need to do here? And I get how presenting in that way can be problematic, but it sometimes has triggered some of your colleagues because of other things happening in that level of pressure that they're feeling, or as you put it, the weight of the robe. So I want to thank you because oftentimes, at least I'm here, very critical of people who are sitting in front of us in your role. And I want to thank those who have put some thought into this role and done the things I think that are really important. Clearly, the work you do is important, but thinking about the way in which you show up and the impact of that, because folks who are not familiar with this go into this, go back out and say, look, this is the experience I have. They have impact on access to justice. So I really appreciate that. Thank you. Thank you, Mr. Chair.
Very much.
Thank you, Senator. Further questions or comments? If not, congratulations on your renomination. Thanks for being with us this morning.
Thank you. Thank you very much, everyone.
Laura Baldini will be next. Judge Baldini, if you could raise your right hand for me. Do you swear or affirm as the case may be the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
Yeah.
Great. Have a seat, and whenever you're ready, we'll take your opening statement.
Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. I'm Laura Baldini. Thank you for the opportunity to appear before you this morning. Thank you also to Governor Ned Lamont for nominating me to serve a third term as a Superior Court judge. Since joining the bench in 2010, I've held assignments in the Hartford, New Britain, Tolland, and Middlesex judicial districts. I am presently assigned to the Middlesex Judicial District, where I am the administrative judge, and I am also the presiding judge of both criminal and civil matters. My current assignment requires me to serve in any court as needed, although I primarily preside over criminal jury trials. Outside of the courtroom, I'm a member of the Judicial Branch Media Committee, the Judicial Branch Wiretap Committee, and I am a judicial mentor. I also volunteer my time to speak with students and other groups about the judicial process. My job is incredibly rewarding and challenging, and it would be an honor to serve a third term as a Superior Court judge if so approved by your committee and the General Assembly. I am prepared to answer any questions that you might have.
Questions from the committee, Representative Fishbein.
I've never been before you, but you're impressive to me. When I reviewed the backup last night, you impressed me, and you impressed me here today. Your presentation. I just wanted to ask you, and perhaps you can't talk about it because it's pending, but the Overton complaint filed October 21.
Thank you for your question to that. That complaint was dismissed.
Oh, great, because I wanted to ask about the timing, because I'm seeing other complaints against other judges that seem to be getting disposed of a lot quicker than it appears the Overton decision was dismissed. So I'm glad to hear that, because that's always an open question with us. And congratulations on your renomination.
Thank you.
Further questions or comments from the committee? Seeing none, thanks for being with us. Congratulations on your
Thank you.
nomination. Okay, next up will be Judge Tejas Bhatt. Judge Bhatt, if you could raise your right hand for me. Do swear or affirm, as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth to help you God or under penalty of perjury?
I do.
Great. Have a seat and we'll take your opening statement when you're ready.
Okay, can you hear me?
Yep.
Good morning, Chairpersons, Senator Winfield, Representative Staffstrom, Ranking Member Senator Kissel, and Representative Fishbein, and all the distinguished members of the committee. Thank you for your time in considering my nomination for reappointment to a second term on the Superior Court. I would also like to thank Governor Lamont for renominating me. My name is Tejas Bhatt, and I have been a Superior Court judge for almost 8 years now. I was born and raised in Bombay, which is now Mumbai, India, and I permanently moved to the United States in the summer of the year 2000 when I started law school here at UConn. I graduated in 2003, and I became a U.S. citizen almost exactly 20 years ago to this day. I've loved living here so much that I've never left, and now my wife and I are raising our 2 young children here. I've been able to fulfill my lifelong dream of public service here in the state, first as a public defender for 14 years, doing criminal trials, appeals, and post-conviction work, and now having spent the last 8 years serving the residents of the state as a judge. I've been assigned to Rockville, Manchester, and Middletown, spending the bulk of that time presiding over habeas and criminal matters with a year or so in juvenile court. I'm also aware that my time on the bench has not been perfect, as I received a private admonishment from the Judicial Review Council in 2023. I can assure you that I took this matter very seriously and have done everything I can to ensure it doesn't happen again. In addition to my duties as a judge, I teach advanced criminal procedure at UConn Law. I routinely judge mock trials and moot competitions there. I'm a co-chair of the Connecticut Bar Association's Diversity, Equity, and Inclusion Committee and the Connecticut Bar Foundation's Constance Baker Motley Speaker Series on Racial Inequality. I've served on the Connecticut Bar Journal's Board of Editors, the Bar Foundation's Committee on Women in the Law, and the History of Attorneys of Color. I served for 4 years in the Judicial Branch's Education Committee, and I have particularly enjoyed participating in Read Across America. One of the things that drew me to the law and the practice of law here in the United States was the promise of justice, fairness, and equity for all. I've strived hard throughout my entire career to bring life to those ideals, and I'm incredibly honored to even be in the position of having the chance to impact the lives of others in a meaningful and just way. I'm forever mindful that what we do is not in the abstract and has real consequences on people's lives. Thank you for the opportunity to answer your questions and the opportunity to continue to serve the state for another 8 years. And I'm happy to answer any questions.
Representative Fishbein.
Thank you, Mr. Chairman. Congratulations on your renomination, Judge. Judge, do you sit on the habeas commission now? The committee that we created a couple years ago.
I have not. As far as I know, no. I know that some names were forwarded, but I haven't heard anything, so I'm saying no.
Okay, I'm gonna have to follow up on that because I do have an appointee to that committee. I did indicate to, I believe Brittany that, I thought that you had the experience, to be on that.
Okay.
So, I didn't issue a letter. I was told a letter was not necessary. But I'm just giving you, notice, I guess.
Oh, thank you.
You've been served. Um, with that, I'm looking at question 28. There's quite a few extensions that you sought on the 120-day requirement.
Yeah.
And, I couldn't tell from the backup why, and there are 8 of them. So I don't know if they fall into a particular basket or they're individual. If you could just explain what's going on there.
So these are all habeas decisions. And these are all decisions on the merits of the case. And each of these cases was extremely lengthy. And I can just give you, for an example, I'm looking at Mr. Crocker, Mr. Bennett, George Laniart. These cases all involved in Mr. Crocker's case. Let's say there were 4 or 5 prior habeases. So these are all cases where I had to read thousands of pages of transcript, listen to multiple days of testimony. George Laniart was a case that was tried in New London, went up to the appellate court, got reversed, went to the Supreme Court. The Supreme Court reversed the appellate court. Then the appellate court heard it again, went back to the Supreme Court, came to me. We had, I think, 13 days of testimony spread over a year. So these are all very, very labor-intensive, fact-intensive cases where it took a significant amount of effort for me to read all the transcripts that were presented, not only of the underlying criminal trials, sometimes more than one, prior habeas trials, also lasting for days, and then write a decision. I don't have the exact numbers in front of me, but I think almost every single one of these decisions I've listed here, my final decision ended up being between 50 to 70 pages. All of this at the same time as maintaining a full trial docket with other cases. When these were happening, when I've been assigned to habeas, we've been trying trials at least 4 days out of the week, 3 to 4 days a week. So these are cases that I'm simultaneously rendering decisions on those cases while also working on these very voluminous, hefty trials, going through banker's boxes of exhibits, evidence, things like that. It is not routine. I mean, I have presided over probably 300 plus habeas trials during my first term. These are 8 in which I sought an extension by agreement with all of these parties. They all agreed to the extension. And in most cases, the extension was maybe a week or 2 just to make sure that I had reviewed everything that I needed to do so that I could write a decision that I was comfortable with and issue it. So
Right.
that's,
Yeah, I appreciate that. And with regard to all of these extensions, it's your practice to say they're not open-ended. You say, can I have another week? Can I have another couple weeks? And that's so
without
that,
a doubt, what I would do is give the parties an estimate of time. And if they object to it, then I will do my best. I will get it out on the 120th day if I need to. But I've always said, I'll let them know I'm asking for 2 weeks, but I'll likely have it done within 3 days, just because I want to make sure that I'm juggling all my other commitments with other trials as well at the same time.
yeah, and that's why I think your input on the commission will be helpful. I have to explain to my wife many times when I come home at night that I'm just brain dead. And we aren't like athletes where we can get on the bike and, we use our brain and we're not machines. And, if you're hearing cases for 4 days, but the case that you heard 2 weeks ago, you're having to at the same time write a decision. I mean, I'm sure you get brain dead at some point, and it's a lot of work. So I do appreciate that input. The other thing, and you did bring it up in your introductory remarks, the Fusco matter. And I think I had heard through the rumor mill or whatever, what the statement was, but the backup doesn't reflect that. So you say that you made what you believe to be an innocuous comment. And do you feel comfortable telling us what that comment was?
I do. I mean, I'm happy to say it. I obviously, I'll preface it by saying it was what I intended to be a lighthearted comment. It didn't obviously come across that way, and I know that the impact is absolutely more important than the intent that I had in making that. It was in the context of a sort of just a lighthearted conversation that we were having before we went out to start trial for the day. I was talking to all the attorneys, the attorney, and I'm trying to be sensitive because obviously it's somebody's personal matter that precipitated it, and I don't want to put anyone's business out there where they may not want it out there. But we were sort of joking, and I think the attorney had said, I'm back to work because I got tired of reading books to a young child, and I sort of intended to jokingly say, you must love the kid, and as
I didn't hear that.
you must love the kid, just as sort of like in the vein of trying to make a very poor joke. Obviously, as I've written in there, and I know you have access to the complaint and the response and those things, we did have a lengthy conversation that day in which it was expressed to me what the impact of my statement was. I apologized then immediately because it was never my intention to put somebody in that position to make them feel that way. I was just trying to sort of go along with the sense of collegiality that we were having with the parties who I've known for a very long time. Had I realized, in fact, not even known, had I realized that the impact of my statement would be so heartbreaking, so powerful to somebody, it's not something that I am. It's not how I live my life. It's not how I raise my children to live my life. It's never something that I would intend to do intentionally to somebody. And I've regretted it. I've apologized for it. In fact, we've had a very productive conversation about a year ago, and we discussed it. I listened to the impact that it had on her, listened for a long time, acknowledged the harm that I have caused, and explained what I was attempting to do, and that I had no intention of causing that damage. And we, I can't speak for her, but we parted on good terms, and we've been on good terms ever since. So that's sort of the,
So-
to answer your question.
And I still didn't hear what it was. What I heard was, well, you mustn't like the child.
No, I said you must love the child. I mean, it was sort of, you must love the child.
Must love the child?
Yeah. I mean, it was sort of like, I don't want to get too much into it in the sense of trying to explain an awkward comment, an awkward joke.
They're
but
being sarcastic,
yeah, unfortunately. Yeah.
which, I mean, I guess if one takes the sarcasm out of it, it's a positive statement. I'm just trying to,
I was going more for something to, in the vein of, oh, don't tell your kid that, right? Like, just, you're saying you came back to work, you're tired of reading books to a child, sort of just with a little bit of trying to make a joke, which went over very badly.
Yeah, no, I got it. And, I've certainly said things in my past that, you apologize and you hope that they, you go on. I guess the interesting aspect of the whole thing is that you, from there, correctly, in my opinion, decided that it would be inappropriate for you to hear the matters of that individual going forward, for the fear that there would be a claim that you were ruled in a certain fashion based upon that complaint. And weirdly to me, there was a complaint that you recused yourself. So, I thank you for coming here and explaining all of that. And once again, congratulations on your renomination.
Thank you.
Judge, no, Senator Kissel, you can go first.
I was just going to say congratulations, Judge Bott. I represent part of Windsor. I'm guessing you live in Senator McCrory's part of town.
I do.
But I grew up in Windsor, and it's great to see someone from my neck of the woods before us this morning.
So since the last time you asked me that question, I have moved in Windsor, but still not within your district.
Okay, well, keep going, keep going. Maybe next time, 8 years from now. Thank you very much, Mr. Chair.
So, Judge Bott, you said in your opening that you took the matter seriously. Talk to me about what steps you took, what training you received, what you did to take the matter seriously after it happened.
Sure. So I'm going to divide them into a couple of different categories. One, there were a number of sort of seminars, classes, presentations that I decided to take to sort of refresh my education and remind myself of the responsibility that I have and the way that I need to make sure that I talk to folks and present myself in front of other folks. So, you know, I have a list here. There are programs in diversity awareness for judges, understanding, appreciating differences, sexual harassment training for judges, the CHRO, sexual harassment prevention training, a presentation on the power of privilege, because that's part of the dynamic that we have as an attorney to a judge, the unconscious bias jury video. Chief Justice Robinson had a presentation on practicing the pause, checking your implicit bias. The judicial branch offers programs on foundations in cultural responsiveness, which is a 2-day program. I'd done that in the past, but I took that again as a 2-day program. And this past December, I finished Foundations in Cultural Responsiveness 200, which is another judicial branch program that's a full-day program. There were many articles also that I read to remind myself of sort of how, as a judge, I need to be careful about what I say, practical tips. And these are a lot for new judges, but it's a good reminder, practical tips for new judges, ethical judicial culture. So you're going to be a judge, ethical issues for new judges, a personal perspective on judicial civility, likely causes of judicial misbehavior and how these causes should inform judicial discipline, and the judicial ethics of ex parte and other communications. And then the judicial branch at their annual seminar every year puts on programs on ethics. And I reviewed a number of those, including judicial ethics code of conduct scenarios, under the microscope, judges' conduct on and off the bench, and judicial behavior. And so that's the education part of it. But the other part of it is, you know, some of the stuff that I do in the Diversity, Equity, Inclusion Committee is recognizing that, and in the work on implicit bias, it's very important to me, is recognizing when you make a mistake and working on yourself. So talking to other judges, talking to folks who, you know, who had been aware of what had happened, to maintain a check on myself and to always think about the impact. And it's very important to me as a judge, and not just in this context, but outside this context, when I'm dealing with folks who appear in front of me, is to recognize the impact of what I do, what I say, the way I say it, the rulings I make to have on lives of the people who appear in front of me. They're not files, they're not numbers. They're people who appear every single day in front of me, and everything I say and I do affects their lives in some way or the other. And so to me, it was a stark reminder that no matter how much I want to have a collegial relationship with somebody, there is a role difference, and I have to maintain that, and I have to be extremely mindful of the way that I say things, what I say to them, the intent with which I say to them, how it's perceived, and to strive as much as I can to ensure that I am not intentionally doing something to hurt another person. And that comes with accountability. It comes with checking yourself. It comes with thinking about the things that you've done, the way you behave, taking everything that I've learned and constantly working on yourself. And so putting all that together is how I've spent the last 2.5 years trying to ensure that I don't cause this harm to someone else again.
So this incident occurred in chambers, correct? It wasn't on the bench?
Correct.
What role do you think that played in it?
Yeah, I think there's certainly, for a lot, in my experience, both as an attorney and in some part as a judge, you see a lot of folks over and over again, and the same folks in the same cases over and over again. And so in chambers, there's naturally, I think, a tendency to have a little bit more of an informal atmosphere. And I think that's sometimes you can slip up and sort of be a little bit less professional than you should ordinarily be. And I think that certainly contributes to the fact that perhaps I wasn't as mindful as I should have.
So what have you done sort of to, and not to steal his thunder, but oftentimes, you know, my learned co-chair here asks judges on new confirmations about their accountability systems.
Yeah, I mean,
how has your accountability system changed as a result of this, or has it changed?
It has. You know, it's very difficult for us in that sense to have that sort of accountability system from within ourselves. Nobody's usually watching us, apart from parties that appear in front of us. So you have feedback from the folks who are in the courtroom, clerks, staff, marshals, things like that. Colleagues come and watch, and that provides some sort of feedback. I'm not sure it's entirely all-encompassing. I've been thinking about how to answer this question. And for me, I think it's more about personal responsibility more than anything else. And I think it's having that compass in your mind about what kind of judge you want to be. And especially when you're faced with evidence that you messed up, I think it is so much more incumbent on you to be extremely mindful of the things that you say, the way you say them, I review my transcripts all the time because I have to write decisions long after the fact. I read a lot of my transcripts to see how I'm appearing. I read other judges' transcripts to see how because I have to do them as part of when I'm in habeas writing decisions, and comparing myself to other judges to see how judges that I emulate would like to emulate comport themselves, behave in court. There is sort of peer feedback with other judges. There are, I know the judicial branch does send out folks to observe judges, and I know they did that with me.
So let me ask specifically about in chambers though, right? Because I mean, I hear a lot of what you're talking about is sort of those external
Yeah.
conversations, and it seems like this happened sort of in chambers in a smaller group setting. Where it's where there's frankly, less eyes, and how has the accountability there changed? Is there anybody you've talked to, or is there any changes in policy? What have you done?
Oh,
to sort of
I'm sorry, I misunderstood what you were saying. Yeah, I mean, obviously I've changed the way I interact. We're never alone. And I mean, I try not to be alone with a party. It'll be an ex-parte conversation in chambers. So there's always somebody else present. But I think it's also remembering that when I'm talking to folks, even in chambers, it is an official judicial proceeding. We are in the role of judge and lawyer, and I limit it to the extent that it's necessary to have conversations about matters that are pending and keep them essentially strictly to business, to what we're talking about with the day's business, and limit it as possible. Clerks are when I'm talking to lawyers before starting the day, clerks are in there with me for the most part to know what's going to happen that day, and that provides an external check as well. But also, more than anything else, it's just knowing that there are things that the ways that you need to behave, and hewing to that.
Yeah, I appreciate that. I think I think it is a balance, right? That you do when you are in chambers, things are a little less formal, but obviously, that's not an excuse for conduct. I was I'm thinking back a couple months ago. I was before a judge I had not appeared before previously, who I was particularly impressed with, and I won't out him, but he or she had a sign in their chambers that said something like, robe judge, right? And I thought it was like a reminder to put your robe on when you walked out of your office, like my clerk puts in my office when I forget to turn my computer off and I can't vote on the House floor. But I think the intent of it was to remember sort of whether you have the robe on or you don't, you're still serving in that particular role. And we face it as legislators, right? That whether we're in this room or whether we're in the grocery store, people see us as legislators first and foremost. They don't see us as Steve, right? And and I guess I would just obviously encourage you to think about what that accountability system is, and the heightened standard that we play in our state system.
100%. I mean, we're judges 24/7, and we have to always behave that way and comport ourselves that way. And I completely agree with you.
Representative Doucette, followed by Senator Fluxer.
Thank you, Mr. Chair. And hello, Tejas. I'm sorry, I must call you Tejas. We've known each other for 25 years. And I believe I met you probably on the first few days that you were a resident of the United States. And we were in the section together, first year of law school. We all helped you acclimate. We thought this funny kid from India helped you acclimate to life in Hartford, Connecticut, of all places. And needless to say, got to know you very well that first year, especially from our contracts class with our famous Professor Birmingham, and outside of the classroom as well. And I can say without a doubt, without equivocation, that your intelligence, your compassion and empathy shone through then, made quite an impression on myself and our other classmates then. And I think it's obvious here today as well. I appreciate your candor in speaking about that admonishment. Again, knowing you on a personal level, I can only imagine it was a very terrible joke. And I don't want to diminish or discount. I don't know any of the details of that. I have not read anything about it. I learned about it from reading your questionnaire this morning. But again, I can vouch for your compassion, empathy, and your humility here today. And frankly, I thought that was one of the better answers that I've heard in my time on this committee to the question of personal responsibility. I'll let Senator Winfield, our chair, be the ultimate arbiter of that, because he has spent a lot of time. And I think it is helpful and important for all of those who sit before us for nomination or reappointment to answer that question and to really think about it. And I think you have done that here today. And again, I personally I feel comfortable in your character and your temperament, and I'm happy to support your renomination. Thank you, Mr. Chair.
Senator Flexer.
Thank you, Mr. Chair. Good morning.
Good morning.
I have a number of questions for you, and I guess I'd start first with the statement that, one of the things that we have to, in this committee, evaluate judges by is that power dynamic. And this is one of the rare moments where that power dynamic is back for you, where you are the person who has to demonstrate that you should be trusted with that power dynamic. And you talked about the classes that you took with Chairman Staffstrom. And one of the classes you mentioned was power and privilege. What did you learn from that class, and what did you learn overall, specifically from all the classes that you read from that list?
Yeah, I mean, specifically from that class, obviously the power of privilege is that privilege is not to be trite about it, but privilege is powerful. And those who have privilege in many ways have a responsibility to not A, abuse that privilege, and B, to be sensitive to it and mindful that they are in a role that even if they don't think they're wielding it, may appear to others that they are, and in fact, they might be wielding that privilege. It is a great responsibility. I mean, I don't take any of this lightly. There's no excuse. And so the privilege that I have by virtue of being a judge and the awesome responsibility that gives me, I think brings about a heightened sense of, and I'll use the word again, responsibility. And that privilege means that you have to be very careful about the way you behave, the way you interact with others, to be mindful of the things that you say, and to be careful that even though you may not believe that you are exerting that is not the case. And I think as simply as I can put it is that, which is it's this responsibility that in some ways to some people with privilege can be hidden. And we have to be aware of it, and we have to be aware of it all times, because it alters the way you interact with people. It alters the way, especially lawyers, respond to you, the way they talk to you. And it's easy for that to go to your head and to continue to abuse that privilege in a way where you exert power over others unfairly. And I don't think there's a way to fairly exert that power over anybody. And so I think that's what that taught me. And overall, it's again, the work is never done. Being a better person, being somebody who is mindful of others, who is sensitive to others, who treats others respectfully, who makes sure that they don't say things that even inadvertently hurt others or cause others harm. It's an ongoing process. I am an ever-changing, ever-growing individual, and it is my goal to every day be better than I was yesterday. And that's part of what I've learned through all of this, is that I made a mistake. I acknowledged it, I accepted it, I apologized for it, and I've done everything that I can to make sure that I don't repeat it as a person, whether as a judge or a human being. It doesn't matter. This is not something that it's something that I've thought about for 2.5 years. It's something that's caused me great disappointment over 2.5 years, that I did something that caused somebody else so much pain. It's not something that I ever wanted to be. It's not how I want to live my life. And every day I do my best to be better a better person, either as a judge or as a human being, to the people around me, to the people I interact with, to the people who appear in front of me, to the lawyers who appear in front of me, to anybody that I see, because that's not who I am and that's not how I want to live my life.
Thank you. I appreciate that. In the complaint that the committee has to review, do you think you would have made the comments that are outlined in the complaint to a man?
Yes.
Okay. And you think in that moment you would have made those comments to a man in that same set of circumstances? Okay.
Yes.
Do you understand the bravery it took for the attorney to go through the process that they did? And you talked earlier about this interaction in the chambers, but what we haven't talked about is that that attorney was uncomfortable in the moment and on that day and went back and talked to you individually. And it's hard for me to understand how in that moment, prior to you taking the list of classes that you've just discussed here this morning, how in that moment, when the attorney went back to you and said, what you said earlier today made me very uncomfortable, and this is why you so quickly brushed it off and didn't just take accountability for it then, because you are a person who makes quick judgments literally every day, and they often can't be reviewed again. And so I'm trying to understand why that attorney, when they went back to you and tried to talk with you then, why they didn't get a better reaction from you in the moment, and we wouldn't be discussing this here today.
So we had, and I'll say this from my perspective, okay? I'm not obviously speaking for the attorney, and the attorney's experience of that meeting that we had when she came into chambers is her experience, and I don't invalidate that at all. That's what she felt, and that's absolutely legitimate. From my perspective, I did not brush it off. We had about a 20-minute conversation. In that conversation, my focus was twofold. One is when she explained that to me, I was horrified that I put her in that position. So my first goal was to apologize, which I did, and apologize for putting her in that spot. Apologize for making an offhand comment that was inappropriate, fell flat, whatever. But my second goal was somebody who would express this to me, and I will not go into what she said because it is private information. But my goal in that moment was to listen to what she had said to me. And then I, at that point, wanted to ensure that I communicated that my intention was not to put her in that spot, to make her feel a certain way. So the brushing aside wasn't brushing aside. It was more of, I don't want to keep harping on this point that has clearly caused you so much harm. I want to apologize for what I have done, but I don't want to continue to subject you to something that clearly has made you uncomfortable and upset, and trying to maintain that sort of, I don't want to say distance, but that demeanor of, I accept, acknowledge, move on. And I want you to know that I understand what's happening. I am supportive of what is happening. I recognize that what you are expressing to me is valid. It is legitimate. And so that was my focus in what we did. We spent about 20 minutes talking. When we left, obviously, I thought that I had adequately conveyed my support, my sentiments, my apologies to her at the time. And then obviously, clearly, I think it was a month and a half later when I got the complaint, I was horrified to see that had been insufficient, and I hadn't adequately conveyed what I had intended to convey at that time, and that it continued to have a negative impact on her.
Yeah, because in the complaint that was reviewed, it doesn't state that you actually apologized, that you instead glossed over the inappropriate comments.
I did apologize.
I guess that's just a conversation between two people, so we can't really know exactly.
Right. And again, I don't mean to, I'm not saying that, this is somebody who obviously this had an impact on her. So her interpretation, her recollection of what happened is legitimate. But all I can say is from my end, I know what I was trying to convey, and that was an apology and an understanding that I had caused some harm, And also, for whatever she had expressed to me, my goal was to also convey support.
So since that conversation and this whole experience, can you tell me about ways where you found yourself in other aspects of your life, either on the bench, in your chambers, or again, any other part of your life where you have done something that has caused someone else harm, and how you've handled it differently than you did this day with this person?
Do you mean in my role as a judge, or?
In your role as a judge, or if there's another example that you'd like to share, that's fine too.
I mean, I'm sorry, nothing specifically is coming to mind, but I guess I would liken it to the approach that I try to take when I'm on the bench, when dealing with folks who are peer in front of me, who've had trauma, who've had something happen. I mean, either as defendants or as victims. I try to speak directly to them, because I know that even though when I'm on the bench, even though I'm issuing a decision, I'm sentencing to someone to something, or to jail or not to jail or whatever. There are folks on both sides who are not going to be happy with what you've done, and I always try to speak directly to them, to explain myself, and to speak in a way that I think folks can understand why I'm doing something, and in my role as a judge, and to ensure that they're heard and their position is heard, and that their feelings are validated and understood by me, and that I've acknowledged that and I've accounted for it, and to speak in a way that reflects their humanity and their individuality, and that I understand that there are folks who are going through a lot of complicated emotions and a lot of complicated feelings, and I'm just coming in and pronouncing a judgment, and they're walking out and their lives are changed forever. And I try to be extremely mindful of that. And I've sought to be even more compassionate in the way I say things, and the way I explain things, and the way I acknowledge that what's being said to me by lawyers, by parties, by victims, by witnesses who appear in front of me. I know it's not a direct answer to your question, but I'm sorry, I'm not coming up with anything that would be a direct answer to your question.
That's okay. I understand that this is, it's hard to perhaps answer something. Maybe you'll have an answer at another point to that question, but I appreciate what you did say. Can you tell me what you've learned from this experience in terms of, I'm here, I'm a state senator, I'm not an attorney, but I've served on this committee for a very long time, and I consider it a great privilege. And one of the things that is unique about my experience and the experience of some of my colleagues is this is still a man's world. This legislature is dominated by men, the judicial branch less so in recent years, but the root of what we're talking about here is built around that structure. And so can you just tell me what you've learned from this experience about that dynamic?
I mean, yeah, absolutely. I mean, I'm horrified, right? Because I have never imagined finding myself in the position where it's that dynamic, because it's just not something I believe. It's not something that I live my life. I've always, part of what I said in my opening statement, diversity, equity, inclusion. To me, it's equality. It's about it's about treating everybody the same, treating everybody fairly, treating everybody with equity. And it just horrifies me that I find myself in a position where everything that this incident demonstrates about me is so antithetical to everything that I believe in, every way that I live my life, with my partner, with my wife, with my kids, with my friends, the things that I believe in, the things that I wish were better in this world, the things that I wish were fairer, and how society should be different, is antithetical to the way this has presented me to you. And it's heartbreaking. It's horrifying. It's to think that this is the image that exists out there, because it is the opposite of everything that I believe in. So as I said, it's 2.5 years. There's not a day that goes by that I don't think about what I did, what I said, and how it impacted somebody else, and how it reflects on me. And it's very disappointing. It's not who I want to be. It's not who I ever was. It's not who I ever want to be in the future. And that's why I keep working on myself every single day to ensure that, as you have said, there isn't or used to be in the branch and in a lot of places of power and imbalance. And I don't want my kid growing up in a world like that. And I don't want my wife having to deal with that. And I don't want to contribute to that. And so when faced with this, it makes you wonder about everything about yourself. And it's just not a good place to be. And I try my best every single day to do whatever I can to live towards that ideal that I have in mind, for not only for myself, but for my daughter.
The attorney that came forward, in doing so, not only complicated their relationship with you if they appear before you, if they continue to appear before you as an attorney, but they also potentially labeled themselves as a troublemaker, right? Someone who doesn't just go along to get along, doesn't just laugh at the jokes. And so what are your thoughts about that? Again, I referenced earlier that I think it did take some courage to go to this degree, to file this complaint, to have this conversation. How would you, what are you doing to make sure that people who come forward like this, who use the structures we have in place to make sure that people who are given the incredible privilege to serve in a role like yours aren't labeled in that fashion, aren't labeled as troublemakers?
I think it's extremely unfair. I don't think that that's an appropriate label at all. My feeling from the minute I got that complaint in the mail was, oh God, what have I done? Right? It's not about what are you doing? Why did you file this? This is somebody who, as you say, it takes a lot for an attorney. And this is someone whose feelings are legitimate. And this is an avenue for redress. It's available. And they absolutely should have used this. I've never had an issue with the filing of the complaint. If somebody feels that way, you absolutely should file that. And to be labeled as a troublemaker, I think that's completely inappropriate.
And so I can have confidence that you've never said to another colleague, another judge, this person is a troublemaker. This person is difficult. This person, I hope you don't have to deal with them in your court.
No.
Okay. Thank you. Thank you, Mr. Chair.
Further questions or comments from Committee Representative Howard?
Thank you, Mr. Chairman. Good afternoon now, Your Honor.
Good afternoon.
I'm looking at your questionnaire and I'm curious where you were between August 2023 and September 2024.
I was in Rockville doing habeas trials.
Okay, so perhaps that's a typo there. Were you there from September 21 to August 2024? Because it seems on the questionnaire, there's a gap. So it says
Sorry, what page are you looking at?
the front page.
Sorry, there may be a typo. I
And
apologize.
I'm not trying to ding you on a typo. I just want to understand because it's relevant to the particular thing that's been widely discussed here, because that's where you would have been.
Oh, yeah, that is absolutely a typo.
So that should be August 2024.
Yep.
So you were doing the habeas docket when this complaint took place. That's what I'm trying to determine. Do you, I see on the back, are you aware of any other informal complaints that clerks, staff, other attorneys have made about your conduct?
I am not.
So I'm not a judge either, obviously, but I would imagine that in 8 years as a judge, you probably talk to people every day.
Every day.
And I would imagine some of these issues are contentious at times. That's why we have judges.
Yes.
Would it be fair for me to assume that, based on what you're saying, that in 8 years of talking to people every single day, to your knowledge, this is the only complaint that was sustained against you?
Yes.
I asked that question because, the chairman talked about, and everybody in this committee talks about, that you're a judge 24/7, which you acknowledge. We're legislators 24/7. I happen to be a police officer in my full-time job 24/7. But I think what gets lost in this state, whether we talk about judges, prosecutors, police officers, lawyers, teachers, legislators, is that all of those people are human beings. And I think I listened to this and that's why I wanted to ask that question because I don't, I don't know folks really up in the Rockville area. I live in southeastern Connecticut, a place where, once again, I'll note the governor of Lamont doesn't seem to know that he can get judges from, but anyway. I don't know, not necessarily folks in that courthouse. When judges, have served in New London County, I have opportunity to talk to folks that I know and say, hey, how are they every day? Are they good people? Are they not good people? Because judges do wield a fair amount of power. So if I were to go to Rockville, Middletown, Tolland area, what would folks say about you in your best estimation?
I mean, it's gonna sound,
It's okay if it's egotistical. I'm just looking for the truth.
I think they're gonna say that I'm fair, that I listen to people, that I treat people with dignity and with respect when they appear in front of me. I think they're gonna say that I listen and I give everybody a chance, that I make my rulings based on what I think the law is, but I understand that everyone has a right to be heard and that everyone comes from different backgrounds and different perspectives, and I do my best to put that in context and the job that I do and to meet people where they are when they appear in front of me.
So would you say, because we've had judges before where, the clerks, again, down in London County, clerks and other support staff in the court say, hey, this guy's like this all the time. This person just had the guts to come forward. You don't think that your colleagues, or the staff that work every day would characterize it that way?
Nope, absolutely not.
All right, so I'm looking at this, I'm just gonna be frank with you here today, in front of my colleagues. I look at this as, a human moment that you've owned, you've taken responsibility for, and I think you've, in my best estimation, done, more than enough, today to acknowledge that you appreciate the position that you're in and that, while mistakes happen, you own them completely and work hard to get past them. And I thank you for your candor and being here and owning that today. Thank you. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Further questions or comments from the committee? Further questions or comments? If not, Judge, thanks for sticking with us. Thanks for putting up with our questions.
Thank you for giving me the chance.
All right, next up will be Judge Wilkerson Brilliant. If you could raise your right hand for me. Do you swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. Have a seat, and whenever you're ready, we'll take your opening statement.
Thank you. Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and all the distinguished members of the Judiciary Committee. I am Donna Wilkerson Brillant, and I thank Governor Ned Lamont for nominating me for a second term as a judge of the Superior Court. It is an honor to be before you today for reappointment. For the past 8 years, I have been assigned to criminal court, juvenile court, and civil matters. Currently, I serve in Hartford Juvenile Court. I love the work I do, and I especially enjoy handling juvenile matters. It has been an honor and privilege to serve the people of Connecticut as a Superior Court judge. Serving the community outside of the courtroom is also important to me. I serve dinners at I'm a Care Shelter, am a speaker and panel judge for the Commission on Human Rights and Opportunities Youth Summit and Kids Court Academy, and I participate in Read Across America. I would be grateful to serve another term. I appreciate your time and consideration, and I welcome any questions that you may have. Thank you.
Questions from the committee. Representative Fishbein.
Thank you, Mr. Chairman. Congratulations on your renomination.
Thank you.
There was a couple things in your background I wanted to ask you about. We ask about cases that are significant to you. And number 10, a lot of the renominations mentioned adoptions. Whether it be serving in juvenile court or being part of the process. And I'm just trying to figure out that number 10, the Aries matter, had to do with an adoption. And is it fair to say that merely because it was an adoption, it was significant to you? I couldn't tell from the squib.
Thank you. No, not merely because it was an adoption. It was an adoption of 3 siblings by a relative. So these three children now who are siblings were able to remain together in the same household, their forever home, with a relative, their aunt. And I thought that was extremely significant because sometimes it is difficult to find an individual to adopt three siblings.
Okay, that's a great answer. On the Santos matter, the complaint, I was trying to follow the procedural history of that. It appears that Santos was the defendant in a civil protection request, right? So he's the respondent in a request for a restraining order of sorts. The petitioner doesn't show up for the hearing, and you correctly, I believe, dismiss the petition for failure to prosecute, and a complaint results. Is that basically the procedure here?
Yes.
Okay. So I don't have a copy of the complaint. What was alleged by the petitioner that you did wrong?
Yes, it was actually the respondent who filed the complaint, and I just want to give you a little bit more background. It was a civil protection order application that was filed against the respondent, who then subsequently complained about me. In that, procedurally, what had occurred was a hearing was set down for that civil protection application. And the respondent requested a continuance because he was a truck driver and he said he couldn't alter his schedule and he couldn't make it to court. I granted his first continuance. Subsequently, in a hearing was then rescheduled. He then filed a second continuance request asking for the same, that he couldn't make it because of his work schedule. I granted that continuance. Again, I still have a petitioner who's looking for a civil protection order against this individual. The hearing was rescheduled again, and at that time, the respondent requested to participate virtually, remotely. I denied his request to participate remotely, as most civil protection order applications are done in person. On the day of the hearing of the civil protection order application, the petitioner did not appear. Neither did the respondent, and I dismissed the matter. The respondent filed a complaint stating that I violated his due process rights because I did not allow him to participate virtually.
Okay, I thank you for that. So it could be that he would have done that, or that it crossed at the time. Okay, well, I thank you for filling that in, and I think that's all that yes, congratulations on your renomination.
Thank you.
Further questions or comments? Judge, let me ask, I assume you're familiar with your judicial performance evaluation scores?
Yes.
So I'm looking at the most recent one for you, which admittedly is a couple years old. It looks like it dates back to 2023, at least the one I have. But your comportment score was below 60%, meaning, you know, two out of every 5 parties that appeared before you found your judicial comportment to be, you know, below grade average, so to speak, which compares with the judicial branch average at that time of about 90%. What's going on there?
Well, I think because, as you stated, that covered a period, the evaluation was, I received that evaluation in January of 2024. It covered the period of 2018 through 2023. The bulk of my time was in Bridgeport Juvenile Matters. I spent 3 years in Bridgeport Juvenile Matters. During that time, well, first, I will say I'm embarrassed by those scores. I was extremely disappointed. I met with my chief court administrator I'm sorry, Chief Court Administrative Judge and Deputy Chief Court Administrative Judge to discuss those scores. And I was distraught. I was somewhat surprised because I do not believe the scores reflect the quality of my work or who I am as a person. I believe what occurred during that time, that the scores, when the scores were rated and included in the evaluation, was during the time of being in juvenile matters. There were a lot of attorneys who were not appearing in court. They were failing to appear. They were not visiting their clients who were children. We were not able to administer justice. I was not able to process the cases efficiently and expeditiously so that the children could have permanency. And so I was stern with the attorneys who were failing to appear and who were not visiting their clients who were children. According to the Office of the Chief Public Defender, there's regulations and guidelines that the attorneys are supposed to visit their clients who are children before each hearing, and they're supposed to provide a report to the court so that the court can move to a disposition, whether that be a transfer of guardianship, a termination of parental rights and adoption, or commitment to the Department of Children and Families. The court, myself, I was not able to process the cases and administer justice. So therefore I was stern. But again, when I received these scores, I was very upset with myself for receiving such low scores. And I immediately spoke with the Chief Administrative Judge of Juvenile Matters to discuss how to make a change, how to do things differently, how to address the shortcomings of the attorneys in such a way that I'm not that stern with, you know, with my disappointment in the way they're handling matters, and the fact that they're not prepared when they come to court. I took a course on comportment with the Connecticut Judicial Institute. I've reviewed prior matters on comportment. I've taken advice from trusted colleagues and judges, again, with my Chief Administrative Judge of Juvenile Matters, who gave me suggestions on how to handle frustrating situations. I also listened to other judges' recordings on how they handle situations that are very similar so that I can tailor what I say so it doesn't come out so harsh or stern. I listened to my own recordings to see whether or not I could have done or said things differently. I also, there's a clerk in Hartford Juvenile Court, and she's been there over 30 years. I think she's getting ready to retire. So she's extremely candid with feedback. So after the hearings, I'll remain in the courtroom. I'll discuss the case with the monitors that are there, the staff, and this particular clerk, and I'll ask, you know, was I too stern? And she's very candid with her thoughts. So I always make sure I take heed of what the staff tell me and how I can change or tailor what I say and how I say it. I think tone is important. I had the Judge Support Services provided an attorney to observe me in court in person and virtually. And that attorney provided me with feedback, and he stated that I should always keep the same tone and remain respectful at all times. I also keep a note on my bench to remain patient at all times, so that reminds me. And again, I have very trusted colleagues that'll be very honest with me, and I always implement any changes that need to be implemented.
So let me just drill down a little bit. So you talked about these hearings, and admittedly, I'm not familiar with the juvenile court system nearly as much, but the hearings for which the attorneys are supposed to submit a report beforehand, who picks those hearing dates? Do the attorneys pick those hearing dates, or does the court assign them?
The attorneys also, yes, the attorneys choose them with the court. So we're all present and we all choose the date together, and they say that they're available. If they're not available, then we move on to another date. Sometimes it could take up to 10 minutes to choose a date that everyone's available.
And how much flexibility is provided to the attorney if they can't get out to visit the client in advance of the hearing and they need to push that date?
A lot of flexibility if we're made aware. The attorneys sometimes do not inform the court. They wait until the day of the hearing and state that they hadn't seen their client in over a year, hadn't seen their client since October, and it's February.
All right. And then you said you met with the chief juvenile judge. Was that Judge Westbrook at the time?
Judge Wynn at the time,
Judge
he
Wynn.
had just taken the position.
The most recent scores we have, like I said, are for the period up through the end of 2023. We don't have more recent scores than that for you. Is that because there just isn't a large enough sample size, or do you know why? Do you have any indication of why we
could-
don't have scores?
Right, it could be because they haven't gathered enough of the sample. Has to be, I believe, an hour or more of a hearing. And also it will depend on whether or not attorneys submit the surveys. So surveys can be sent out, but if they're not completed and returned, there wouldn't be enough of a sample size.
Is there any, maybe this isn't quite a fair question, but any assurances or sort of data you can share with us that would lead us to believe the comportment scores next time we get them will be improved from the last go round?
They will definitely be improved. As far as the data, I could say that, well, I will say that I've never had a complaint filed against me with regard to comportment. The two complaints that were filed against me, one we mentioned earlier, Representative Fishbein raised with regard to a denial of a virtual request. The other one, Daniel Roberts, has to do with a probate appeal. And I dismissed it because he filed the appeal against the probate court. There haven't been any complaints that I'm aware of. I do speak with the staff regularly, and I've gotten great feedback that I'm a great listener. I respect the people that come before me. I will say that through this process, I have learned to give the attorneys more grace and more understanding when they don't appear. So I don't respond or react in such a stern way. So I've learned from this. I've self-reflected. Those are my internal factors, if you will. And I know this committee has stressed internal and external factors. By listening to myself and the recordings, like I said, I've learned a lot that everyone has busy lives. And even though I do expect the parties, the litigators, the attorneys to appear prepared, I have provided a lot more understanding and grace.
I know you were with the CHRO before going on the bench. Were you ever in private practice or no?
Yes, I was in private practice from 1995 until 1999 when I took the position with the Commission on Human Rights and Opportunities.
Okay. Yeah, because I mean, look, I get it's a balance, right? I mean, obviously attorneys need to be prepared when they show up in court, no doubt about it. But as we continue to talk about access to justice issues and, you know, whether it's pro bono, low bono, particularly in juvenile court, where maybe the lawyers aren't making quite as much per case as folks in other parts of our system. I think it's important that we strike the right balance between, wanting lawyers to take on cases because it's better than the alternative of having folks not represented, well at the same time. And I get that's a delicate balance that the branch is going to have to strike. So, Representative Fishman.
Thank you, Mr. Chairman, and I apologize for going after
No,
you.
you're fine.
I did get offered the scores today. I indicated that I didn't have time to, look at them during the hearing. So, I do thank you for bringing that to our attention. I will flag that there may be an issue here. In that, looking at the backup, the nominee before us has been, it appears, in juvenile court for almost the entirety of the term. And you did mention that you don't know a lot about the juvenile process, but those courtrooms are sealed. If it's a judge who's yelling at pro se parties in a civil courtroom and a housing issue, there very well may be a reporter in that courtroom, right? And then you're going to see it in the news. But the reporter can't go into the juvenile courtroom and actually view the comportment. In juvenile court, most people are represented. Because many times you have criminal aspects of that, and there's a right to counsel, and the state pays for a lawyer. In my experience, I very rarely have seen pro se parties in juvenile court. And we know that, I think the last time we got a stat, it's like 80% of the family cases are pro ses, right? So we don't know how that dynamic here, and yet the result is the comportment scores that we're getting. So I heard the answers. I think there's another nominee that, as we go through this process, maybe in a similar situation. I just, I guess flag for the branch that maybe keeping people in juvenile court for almost the entirety of their term may not be good for the system. Because looking at the last 8 years, it appears that there was 1 year, the first portion of the term was May of 2018 through September of 2019. The assignment was criminal. And then for the next 6 years or so, it's only juvenile. And then in September of 2024, there's assignment to civil. That doesn't last a year. So September, October, November, that's like 7 months. And then it's back to juvenile. So I just flagged that for what we're doing here today. So thank you, Mr. Chairman.
Further questions or comments, Representative Osborne?
Thank you, Mr. Chair, and good morning, Your Honor. Thank you for being here. I know this can be a difficult process. I want to follow up on a question that Chairman Stafford asked you, because it's one that came to my mind as well. Now, you mentioned you had been in private practice from 95 to 99. When you say you were in private practice, were you a litigator? Were you going to court? Did you have any court experience before you became a judge?
Yes, I did. I practiced primarily in juvenile law, and I litigated in Hartford Juvenile Court.
Okay, thank you very much. No further questions.
Further questions or comments? Seeing none, congratulations on your nomination. Thanks for being with us.
Thank you.
Next, we will turn to Eugene R. Kilistro of Guilford. You could raise your right hand for me, sir. You swear or affirm as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? Great. May I have a seat whenever you're ready?
Good afternoon, Chairman Winfield and Staffstrom, Senator Kissel, Representative Fishbein, and all esteemed members of the Judiciary Committee. My name is Gene Calistro Jr., and I am pleased to appear before you today I'd like to thank Governor Lamont for nominating me for what will be my second term as a Superior Court judge. It has been an honor and a privilege to serve in this capacity. Since my appointment to the bench in 2018, I have served in the Waterbury Juvenile Court, where I presided over delinquency, child protection matters, as well as adoption proceedings. Subsequently, I was assigned to GA2 in Bridgeport, where I presided over all criminal matters. In 2020, I was assigned to hear virtual habeas trials in Middletown Superior Court during the COVID pandemic. In August of 2020, I was assigned to GA23 in New Haven as the presiding judge of criminal, where I presently sit, hearing our dedicated gun docket, competency hearings, sentence modification hearings, and all other criminal matters. I presently serve as chair of the investigative grand jury panel, having served since 2020, and have served for 3 years on the Judges Education Committee. I also sit as a regular member of the Judicial Review Council. Outside of court, I am an active member as well as past presenter, the National Alliance on Mental Illness, NAMI. I was a past treasurer of the Connecticut Judges Association for 2 years and a Quinnipiac University Law School mock trial judge from 1995 to 2023. I enjoy being a court liaison for the Connecticut Bar Association's court visitation program, hosting high school, college, and law school students at the courthouse. I would be deeply grateful for the opportunity to serve the residents of the state of Connecticut for a second term as a Superior Court judge. I thank all the committee members for your time and consideration, and I welcome any questions that you may have. Thank you.
Questions to the committee, Representative Fishbein.
Thank you, Mr. Chairman. Congratulations on your renomination.
Thank you, Representative Fishbein.
Living in Guilford, you must do some fishing?
I do. Clamming and crabbing as well.
Oh, wow. Man after my own heart. I grew up in Bradford and did a lot of that. But I heard you're not a very good fisherman. I was contacted by a colleague who was telling me that you can't catch a fish for anything. So I just wanted, we used to ask about hobbies in the backup. We don't do that
I have a
anymore.
photo, Representative Fishbein. A couple of weeks ago, I caught a 46-inch barracuda in Florida. So
Okay.
I disagree, sir.
But that was Florida, and you live on the shore here
Oh, okay.
in Connecticut. So anyway, but congratulations on your renomination, and thank you, Mr. Chairman.
Thank you, sir.
Judge, just a quick question for you. I know you had I believe you had a pretty extensive career in the state's attorney's office before going on the bench, right?
Yes, sir.
Our illustrious chief court administrator likes to tell me that former prosecutors make better judges than defense lawyers do. That they're tougher on the prosecutor and make the prosecutor prove their case more and tend to be more lenient in sentencing. Do you want to agree or disagree with the chief court administrator?
Well, now.
I'll note she stepped out of the room, so you're good.
Okay.
She won't know what you said.
Right. Well, my honest answer is that, the prosecutors are tested with power. And now that we become judges, I still think that we have to be fair and impartial to both sides. So I wouldn't lean one way or the other, but I certainly think that we have the tools, we've been tested with power as a prosecutor. And I say we make the best judges.
Those were my words in interpreting, not a direct quote from the chief court administrator, but you said it a lot more eloquently than I did. So thank you very much. Congratulations on your renomination.
Thank you, sir.
I think you're good, unless you want to stay with us longer.
Gonna go fishing.
Sort of like when the court says, counsel, anything further you need to add? All right. Carl Carasquila. Raise your right hand for me. Do you swear or affirm, as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? Great. Have a seat whenever you're ready.
Thank you.
Record reflect Representative Osborne, I believe, is recusing herself on this one. Yes.
All right, thank you. Good afternoon, Chairman Winfield, Chairman Staffstrom, Senator Kissel, Representative Fishbein,
and members of the Judiciary Committee. My name is Carol Carasquilla. Thank you for the opportunity to speak with you today. I would also like to thank Governor Lamont for nominating me for what will hopefully be my second term as a Connecticut Superior Court judge. The experience and honor of being a judge has been intellectually stimulating, challenging at times, stressful at times, but ultimately the most rewarding and gratifying professional experience of my life. When first appointed in 2018, I was assigned to the GA in New London. There I presided over criminal, motor vehicle, and domestic violence dockets. From September 2019 through August 2021, I served in the Hartford Family Court. I presided over dissolutions of marriage applications, custody and visitation applications, temporary restraining order applications, ex parte orders of custody applications, pretrials, all stages of pre and post judgment litigation, trials, and the writing of decisions. From 2021 to 2022, I served in the Manchester GA, where I again presided over criminal matters. In 2022, I served in the Hartford Community Court for 1 year. The Hartford Community Court handles quality of life type of crimes, misdemeanors, low-level offenses such as shoplifting, disorderly conduct, breach of peace, prostitution, etc. That court focuses on restorative justice, and its purpose is primarily to reduce recidivism by replacing traditional jail time and fines with immediate court-supervised community service and mandatory on-site social service referrals to address the underlying issues such as addiction, mental health, and housing insecurity. In September 2023, I returned to the Hartford Family Court for 1 year, and I am currently serving my second yearly assignment in family court in the Tolland Judicial District in Rockville. Outside of the courthouse, I participate in the Read Across America program each year. I've served multiple times as a judge for high school mock trial competitions sponsored by Civics First and also the Connecticut Bar Association. I've also judged law school moot court competitions sponsored by the American Bar Association and judged written essay contests for high school students sponsored by the Connecticut Bar Foundation. At home, I am transitioning to an empty nester, and I am the proud mom of 2 wonderful young adults. I would be honored to be reappointed to serve another term as a Superior Court judge. I welcome any questions that you may have for me at this time.
Questions from the committee? Questions from the committee? If not, thanks for being with us. Congratulations on your renomination.
Thank you very much. Thank you.
Right. Judge Susan Connors is next. Judge Connors, if you raise your right hand, do you swear or affirms the case may be the information provided this committee be the truth, the whole truth, and nothing but the truth? So help you God under penalty of perjury?
Yes, I do.
Great. You can have a seat, and whenever you're ready, we'll take your opening statement.
Thank you, Representative Staffstrom. I see that Senator Winfield, Senator Kissel, and Representative Fishbein are not present, but I wish them a good afternoon as well if they're listening, and to all distinguished members of the Judiciary Committee. Like my colleagues who have gone before me, I'd like to extend my deepest gratitude and appreciation to Governor Lamont for nominating me for what will be a third term as a Superior Court judge. Since my last reappointment, I spent approximately 1.5 years in Hartford Civil Court, with the remaining 6.5 years having been in family court in New Haven and as the presiding family judge in New Britain, Hartford, and now Norwich, where I currently sit, and also serve as the assistant administrative judge for the New London Judicial District. In these assignments, I have had the privilege to work with amazing colleagues and support staff who have assisted me in my daily responsibilities. Off the bench, I have served on the State Marshal Commission. I have been president and treasurer of the Connecticut Judges Association, a mentor for the University of Connecticut School of Business Administration, and a liaison and presenter at the Connecticut Judges Institute, as well as being a volunteer in various organizations. I greatly appreciate your consideration so that I may have the opportunity to serve another term. Thank you for your time. I will do my best to answer any questions you may have of me.
Are there questions from the committee? Yeah, go ahead, Representative.
Thank you, Mr. Chair. I would just like to publicly say thank you to you, Judge, and it's good to see you here today. And as you helped a member, an elderly constituent in the district that I serve in, and I just wanted to thank you and thank you for all the good work you do in the Norwich community. Thank you very much.
Thank you for.
Thank you,
those
Mr. Chair.
words.
Further questions or comments? If not, congratulations, Judge. Thanks for
Thank
being
you
with
so
us
much.
this morning. Judge Dayton?
Good afternoon.
Good afternoon, Judge. If you could raise your right hand for me, do you swear or affirm as the case may be, the information provided to this committee be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. Have a seat whenever you're ready.
Thank you. Good afternoon. Again, I see that Chairman Winfield's not here. But good afternoon, Chairman Staff.
And just so folks are aware, there are other meetings going
know,
on in the
everyone
building
told me.
today, and there are TVs. They're watching. They're just between different meetings.
So my best also to ranking members Kissel and Fishbein and all the distinguished members of the Judiciary Committee. My name is Tracy Lee Dayton. I'd like to thank also the governor for nominating me to serve a second term as a Superior Court judge. I was appointed to the bench in May of 2018. I spent the first 4 years of my term in Bridgeport in the GA. 3 of those years I served working on the arraignment docket and the domestic violent docket, and then I was 1 year as the presiding judge. After that, I was assigned to the Bridgeport JD for 3 years. I initially was presiding over criminal trials and then spent 2 years as the presiding judge for criminal matters in that JD. In September 2025, I was assigned to the New Haven JD. I am again the presiding judge for criminal matters, and I'm also the assistant administrative judge. In addition to my assignments, I have served on the Criminal Jury Instruction Committee. I am on the Sentence Review Division right now. I previously served on the Judicial Review Council, and I love participating in the perks that we get as a judge, Read Across America, Career Day, and mock trial. We have one of our mock trial folks here. It's a privilege to have such a challenging and rewarding job. I would be very grateful for another 8-year term. And thank you very much. I would be happy to answer any questions that you have.
Questions or comments from the committee? So Judge, let me ask, so I'm looking at your evaluation scores. Legal ability, 95%. Management skills, nearly 90%. So very good. But then there's a pretty sizable dip on comportment.
Yeah.
74%. Why do you think that is?
So obviously I'm hypothesizing, but based upon the timing of when these occurred, the pandemic really threw the judicial system into disarray. The great majority of the courts were closed and business virtually came to a halt. As we tried to fully reopen, I was the presiding judge first in the Bridgeport GA and then the Bridgeport JD, which was one of the few courts that remained open during the pandemic. And so there was a huge caseload. So I had a responsibility of trying to get things back on track. And I worked very hard to remedy the backlog. And I asked people to work hard with me as a team to address the situation. And there were certainly some growing pains, and not everyone liked what I asked them to do. But it was really important that we not have people sitting in jail for long periods of time waiting for their cases to be heard, and that complainants and victims had access to the courts and could see that the cases were moving along. And really the goal was to get the court back on its feet and to do justice. And that was rocky some days.
Okay. So what were some of those decisions that you made that you think kind of rocked the boat, so to speak?
I asked everybody to come back to court for every appearance, because what we were finding, as you heard from one of my appears is that folks, attorneys were not visiting their clients or meeting with their clients either in jail or out of jail. Prosecutors were not providing discovery in as timely a manner as I thought they should. And cases were not moving. And you need people in court to get business moving, either to do trials or to resolve cases, or even to have a case nollied. Whatever's going to happen with the case, the people need to be in court. And it's very hard to hear defendants come to court and say, I haven't seen my attorney in 3 months.
So you're not going to get an objection from me on forcing people back into court. I think
Okay.
people, some folks, I think know I'm a big proponent. I think everything but the 15-minute status conference should probably be back in court, but certainly dispositive motions, right? But and while we're at it, back in the office 5 days a week too. But that to me, and maybe it's just the eye of who fills out the summary, but that to me would seem more like the management skill question than it goes to comportment. I mean, when I think of comportment, I sort of think of how does someone, how do they react on the bench? Are they collegial to folks? Do they, do they allow the parties and the litigants to sort of make their case? Is the tone the right tone on the bench is sort of what I think about comportment. Again, not that I've appeared before you, but have you heard those types of concerns from folks on your demeanor on the bench at all since you've been on the court?
No, actually. I think that the feedback that I've gotten is that I do a very good job listening to people. I spend a lot of time listening to defendants talk, sometimes even when their attorneys don't want them to, because it's their lives, it's their case. And if they wish to speak, I'm certainly going to listen and take it into consideration to the extent possible. I certainly allow attorneys on both sides to be heard and make their arguments. I am not beyond changing my mind after hearing an argument, after hearing a defendant speak. And I always welcome hearing from complainants and victims and their families for both sides. So I hear what you're saying for sure, that usually you would think of it as on the bench. I'm not sure that's what it was.
Okay. All right. Fair enough. You would know better than I would. Further questions or comments from committee? Representative Fishbein.
I just wanted to respond to the colloquy about remote proceedings. I think that the system has converted to a process that I open up my Outlook calendar and all of a sudden I learn that I've got to be in court in 2 weeks and I had nothing to do with the scheduling. And, if we're going to be creating rules here or just throwing out propositions, I think any of those matters should be remote. And then at least you have some flexibility. But I mean, every day I open up my calendar. That's what I was going to ask the prior nominee about forcing things onto people's calendars, because when people don't show up for court and then you're scheduling a subsequent thing, I don't know how you can say that there was assent if the person wasn't in court. And that's a problem, because I know that the motions for continuance have like 8 times what it was pre-pandemic. I mean, how many motions for continuance do I have to file like every week that I didn't have to file previously? So, you did make a suggestion.
Maybe we need to do is go out for beer and hash all this out with that, not take it out on poor Judge Dayton here.
No, I know. I
mean, I think it's sort of just, yeah. I'll buy. How about that?
You threw out a suggestion. I just didn't want
did.
that, silence is an assent, right? And I just didn't want to be assenting to your.
I was being sympathetic. when she said
Congratulations
she
on your
forced
renomination.
people back into court.
Should I go?
You should. Yes. Thank you.
Excellent. Thank you. Thank you very much.
All right. And on that lovely note, you want to get me started on trial dates and how inflexible they can be? All right. Judge Nuala Droney. You can raise your right hand for me. Do you swear or affirm, as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? Great, thanks. Have a seat, and whenever you're ready, you can tell us what you think about remote proceedings.
Thank you very much. And good afternoon, Chairman Winfield, Chairman Staffstrom, Vice Chair Flexer, Vice Chair Gadker Wilcox, Vice Chair Fazino, Senator Kissel, Representative Fishbein, and all distinguished members of the Judiciary Committee. My name is Nola Droney, and I am thankful to Governor Lamont for nominating me for a second term as a judge of the Superior Court. It has been a great honor and humbling privilege to serve as a trial judge since May of 2018. Since that date, all of my assignments have been criminal. First, I was honored to serve in GA 21 Norwich from 2018 to 2021. And since September of 2021, I have served in Hartford, first as the presiding judge of GA 14, and for the past 2 years as a criminal parte trial judge. I've also had the privilege of serving as the administrative judge for the Hartford Judicial District since 2024, having served for a year before that as the assistant administrative judge for Hartford. I am a member of the Criminal Jury Instructions Committee, the Education Committee, and the Executive Committee. Outside of my role as a judge, I serve our community as a Girl Scout troop leader, lacrosse coach, and a room parent. I'm committed to civics education, the branch's civics academy, judging mock trials and speaking on school panels and continuing legal education panels. I'm so thankful for the opportunity to serve the people of the great state of Connecticut and would be grateful for the opportunity to continue to do so as a Superior Court judge. Thank you for your time, and I welcome any questions you may have.
Questions from the committee? If not, I just want to take an opportunity to not just commend you, but commend a number of folks today who have really highlighted their involvement in the community and the service they provide on civics and on a whole host of issues. I think, you know, a couple of years ago, we had a class of judges before us, and I won't remember the year and I won't call them out, but we kept going through the backup and we kept saying, all right, well, what do you do after work? You know, what do you do in your spare time to, you know, you're an independent constitutional officer, you're a representative of the state of Connecticut. How are you out in the community sort of, you know, bettering yourself, bettering the community? And we didn't get a whole lot of responses back. And I'm heartened by what I've heard from this class so far this year in terms of, I think, people taking it seriously that, you know, there's a role for judges to play in you know, explaining what they do and what the role is and being role models in the community. So I appreciate you highlighting that. So
Thank you very much.
no further questions. Thanks for being with us. Congratulations on yours. All right. We are on to page 2. The Honorable Barbara Hoffman of Clinton. Judge, do you swear or affirm, as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
Yes.
Great. You can have a seat whenever you're ready.
Good afternoon, Chairman Wilfield, Chairman Stratham, and ranking members Kissel and Fishbein, and distinguished members of the Judiciary Committee. I would like to thank Governor Lamont for renominating me for a second term as a judge of the Connecticut Superior Court. It has been my honor to serve in this capacity for the last 8 years. Since my appointment, I have been assigned to Hartford, New Britain, and Waterford. For the last 5 years, I've been the presiding judge in Waterford Juvenile Court. I am thankful every day to have the opportunity to sit in juvenile court. I have considered it an honor and a privilege to serve as a judge of the Superior Court, and I would welcome any questions you have for me. Excuse me.
Questions from the committee? Representative Fishbein.
Thank you, Mr. Chairman. Congratulations on your renomination. Judge, looking at the backup, you've never sat in any other court but juvenile. Is
I
that
have not.
okay? Is there a reason for that?
Well, my first assignment was juvenile, and I was surprised. I didn't have any background in juvenile or child protection, and I loved it. And I have continued to ask to be assigned to juvenile. I don't know why I haven't been assigned somewhere else, but they have honored every one of my requests.
Okay, and you were first in Hartford juvenile, then New Britain, and then Waterford, and you're still at Waterford. So you've been at Waterford for the last 6 years doing juvenile.
Mhm.
Has anybody ever asked you to go to a different court?
No.
Okay. In the backup, you addressed, it's in, question 25, the ET matter, not the guy on the bike, the alien, but, and in your squib, it appears, use the acronym because more than likely a juvenile case has some level of ceiling to it, and that's usually what we do in many juvenile cases. And you said Mr. E.T. appeared before the court virtually. Mr. Zuma.
Oh.
And then you go on to talk about Mr. Zuma. So am I to assume that you interchangeably use the proper acronym with disclosing his actual last name?
I apparently did, yes.
Okay. Okay. Also in response to question 28, which talks about extensions, did you fail to render a decision within the appropriate time allowed? And you said, yes, one time the clerk notified me and I had the decision out the next day. Can you give us some more, I mean, considering that this is definitely a juvenile case, right? Because you haven't served anywhere else.
I think,
What was going on here?
I think it was a child protection case. And when I was notified, I knew exactly what had happened. I had come out of court, I had placed the documents in my inbox and intended to get to it. And then for whatever reason, got involved in other decisions and cases. When I was filling out this application, I went to the clerk trying to locate that file again because I was very upset at the time that I had missed on the 120-day deadline. I had the clerk approach the attorney who had called because he called the clerk the day after on the deadline, and he could not remember what the case was. I did not remember any specifics about it. I had the clerks research any possible cases that this attorney handled, that the decisions were late. She could not locate anything. And the only thing I can say, it must have been a motion or something that could be easily addressed because I had the decision out the next day.
Okay, you gave me a lot to unpack there. So on one hand, if it was an easy decision, then why didn't it get issued a lot quicker?
I don't, it may have been on a day where the dockets were full and I just turned around and started doing the next thing and did not get back to it. I take full responsibility for it. It landed in that box and I I guess I figured I would get to it and got involved in other stuff, other things.
Okay, which begs the question, the delay of time, 120 days is generally 4 months. You admit here today that you had absolutely no recollection as to anything involving this case, right?
Right.
And yet you were then able to render a decision the next day.
Oh, no, at the time that it was brought to my attention, I went looking for it. I had the information. I can render the decision. Today, looking back, trying to locate that decision and what the circumstances were, I can't tell you.
Okay, so that's a little bit different than what I'm reading on the paper. Okay. So when did this happen?
I was in Waterford, so I would imagine it happened about 3 years ago. And that's just a guess.
Okay, and so there's no way for the judicial branch for the state of Connecticut, which spends millions of dollars on that branch, to figure out a particular case that was issued
Without the
by
name
you
of-
within the last 3 years?
Yeah, without the name of it, no. I mean, and I diligently tried to find out.
Okay. I think that's all that I had. I'm just really confused and concerned, but I mean, if that's the process, yeah. All right, thank you, Mr. Chair.
Further questions from committee members? Seeing none, thank you for joining us.
Thank you.
Next up is Judge Daniel Clow. Judge Clow, can you please raise your right hand? Do you solemnly swear or affirm, as the case may be, that the information you provide to this committee is the truth, the whole truth, and nothing but the truth, so help you God, or under pains and penalties of perjury?
I do.
You may be seated.
Thank you.
Good afternoon, Chairman Winfield, Chairman Staffstrom, Senator Kissel, Representative Fishbein, Vice Chair Flexer, and other members of the Judiciary Committee. It's an honor to appear before you today. I thank Governor Lamont for nominating me to serve a second term as a judge of the Superior Court. When I was first nominated to become a judge in 2018, my late daughter said to me, "Daddy, you're going to have great power over people's lives. The power to put them in prison or to keep them out. The power to set reasonable bail or to set a high bail that they can't pay. Use that power wisely, Daddy. Be fair, just, and have empathy." And I remembered those words that my daughter spoke. That's a quote. And I carry them with me every day into the courtroom or in chambers, wherever I am, and try to act the way that she asked me to. I'm currently assigned to the complex litigation docket in Waterbury. My previous assignments are reflected in detail in the questionnaire, but in summary, I've spent 4 years as a family court judge, 2 years in New Haven, 2 in Hartford. I have 2 years of civil experience in Hartford, 1 year on the tax and administrative appeals docket in New Britain, and my first 3 months as a judge were in the GA in New London. In addition to my regular judicial work, I serve on 3 committees: the Judicial Ethics Committee, Judicial Education, and the Commission on Continuing Minimum Legal Education. During the past 2 years, I've presented ethics programs to new judges at what we call judge school or pre-bench, also to my colleagues at the Connecticut Judges Institute, which is our continuing legal education program. I also write an ethics newsletter for the branch. Outside of work, I'm a fellow of the Connecticut Bar Foundation. I continue to serve on the board of the Connecticut Foundation for Open Government, and I continue to teach First Amendment and privacy law at UConn Law School, where I've been an adjunct faculty member since 2003. In my free time, I've written a memoir about my daughter, which will be published in the spring of 2027. I play a lot of jazz piano, occasionally hosting Name That Tune and musical Jeopardy games, both online, Facebook Live from my living room, and also in person. I've played numerous times in center court at 95 Washington for colleagues before court opens, just to have fun. And I also play on occasion for our senior citizens in the community. I consider myself incredibly fortunate to serve the state of Connecticut as a Superior Court judge. I would be grateful for the opportunity to serve another term. Thank you for your consideration, and I would be delighted to answer any questions you may have.
Thank you, Judge Clow. Questions, comments from committee members? Representative Fishbein.
Thank you, Mr. Chairman. Congratulations, Judge, on your renomination.
Thank you.
You know, I knew you before you got on the bench, and my impression was always that you're just a guy looking to have fun, and you're obviously still having fun. So I appreciate that. And I also appreciate, I've been before the appellate court a lot in the last year or so. And the first brief that I wrote, I hadn't done one in a while. And I ran across a book that you wrote. It's 103 pages long, but every single word is helpful.
I'm so glad. The little book of appellate tips. Yeah,
it's available online. There were so many tips in there that I found to be very, very, very helpful. And I appreciate you putting that out there. It's in the public domain. Very helpful. So
thank you for sharing that with me.
Yeah. Once again, congratulations on your renomination.
Thank you very much.
Further questions, comments from committee members? Judge Clow, I appreciate you shedding some light on your diversity of experience on the bench, having assignments on tax court, family court, GA, and now complex lit. Is there any one assignment that you feel has been especially formative in shaping your judicial comportment, your skills on the bench? What really sticks out to you in your experience?
Every assignment has offered sort of unique experiences. The family court, which was a shock when I was assigned very quickly after going on the bench because I had zero experience with family, but I found it incredibly rewarding, because of the constant level of interaction with litigants at very difficult times in their lives. And it was an opportunity to try and help them through this difficult period, consistent with my legal obligations. So I found that rewarding because of the constant interaction with parties on the bench, listening to witnesses, testimony, et cetera. The administrative appeals assignment was right up my alley. I was primarily a civil appellate lawyer for most of my career. And I am very happy, as Representative Fishbein, I think, noted, just loading up and reading briefs, having oral argument on legal issues on a fixed record. So there isn't a single assignment that I would say stands out as better than another one. Each one has offered unique, positive experiences, but very different experiences.
Much appreciated. Further questions, comments from committee members?
Mr. Vice Chair.
Yes, Representative O'Day.
Thank you very much. Good afternoon, Your Honor.
Good afternoon, Representative O'Day.
It's been quite a number of years since we rode the elevator together at 1 Goodwin Square.
Well, and I remember the last time I was here when you pranked me out in the hallway and said I had missed being called. So I turned white as a sheet, as you may recall.
I do recall. And for anybody that, so Your Honor, you have recovered from your billable hour blues song being on the bench. You don't have to worry about it, but there's a number of us in private practice that are still suffering from the billable hour blues. If anyone is interested, he does have a number of albums and songs out. So, but Your Honor, on a serious note, now that you've come through, you're a very good writer. Any words of wisdom for, we're going to have a group of new judges coming out on lessons learned in your first term, if you will.
Oh, well, yeah, I mean, you mentioned my writing. So are you asking for lessons learned about writing or more generally?
I'm sorry, to be clear. So I've been told that a number of judges tend to watch these proceedings for when they're coming up for either appointment or reappointment. And for the benefit of the judges who are coming up for, or potential judges coming up for initial appointment, now that you've been through a year, 8 years, and you're coming up for your reappointment, any life lessons or words of wisdom that you would give the attorneys that are coming up to become first-time judges?
I do. The value of it, I don't know, but I bring an attitude to the bench that I'm an incredibly fortunate public servant. It's a position that I had aspired to, and was very fortunate that Governor Malloy nominated me 8 years ago. When I go on the bench, my job is to listen. First and foremost, it's to listen to litigants, to ensure that when they leave my courtroom, they truly feel that they have had their day in court, that they've had due process, that they've been heard. And I think being an active listener as a judge is a skill that is undervalued. So one piece of advice is the relationship of talking to listening should relate to the number of ears to mouth. Listen more, speak less, make sure everyone in your courtroom, attorneys, parties, feels they've been heard, and then explain yourself in your decisions with great care.
Thank you. And God bless you. I'm sorry. I know since your reappointment and your daughter's passing, God bless and prayers to you and your family. And thank you for your years of service to the state of Connecticut. Good luck going forward.
Thank you very much, Representative O'Day.
Thank you, Representative O'Day. Further questions, comments from committee members? Seeing none, Judge Clow, thank you for being with us. Congratulations on your renomination.
Thank you very much.
Judge Kowalski, come on down. Please raise your right hand. Do you solemnly swear or affirm, as the case may be, that the information you provide to this committee is the truth, the whole truth, and nothing but the truth, so help you God, or under pain and penalty of perjury?
I do.
You may be seated.
Thank you.
Please feel free to provide your opening statement.
All right, thank you very much. Good afternoon, co-chairs Senator Winfield and Representative Stavstrom, ranking members Senator Kissel and Representative Fishbein, and distinguished members of the Judiciary Committee. Thank you for your time and attention today and for all of your work on behalf of the people of Connecticut. I also wish to thank Governor Lamont for nominating me for reappointment, and I wish to thank my wife and my adult children for putting up with my schedule, which often involves doing things outside the home or in the home nights and weekends related to my judicial duties or my community activities. During my first term, I have served in all 3 judicial district courthouses in Fairfield County, spending 3 years in Danbury, 1 year in Bridgeport, and almost 4 years in Stamford. In Danbury, I spent 8 months in GA3, and the balance of my time there handling civil matters, including the foreclosure docket. For the past 5 years, I've been assigned to family court, first spending 2 years in Stamford Family, then 1 year as the presiding family judge in Bridgeport, and since September 2024, I have been the presiding family judge in Stamford. Outside the courthouse, I serve as the president of the Raymond E. Baldwin American Inn of Court, and other activities have included serving as a past president of the Connecticut Judges Association, participating in Read Across America annually, and addressing students and community groups as part of the Judicial Branch Speakers Bureau. I understand the substantial responsibilities of judicial service and the real human consequences of our decisions, particularly in family court. Each day, I strive to approach this role with humility and a deep respect for the privilege of serving the people of Connecticut. And with that, I welcome any questions you may have.
Questions from the committee, Representative Fishbein.
Thank you, Mr. Chairman. Congratulations, Judge Kowalski, on your renomination. We hear complaints about the family court down in Stamford. And I know you're relatively new. I mean, you've been there since September of 2024. I know that our courts like to try and turn divorces within a year. Do you have any statistics for us as far as where you are on average and whether or not it's gotten better down there?
Sure. Yeah. I can say it's definitely gotten better. And I can give you just a couple of general statistics. Pre-COVID, the number of pending divorce cases in Stamford for the few years before that, which hadn't gone to judgment yet, this will be total cases, custody and divorce, was in the low 600s, maybe 600 to 650. Big peak during and right after COVID, right? That number was still about 600 in September of 2024 when I started as PJ. We had a period about several months before that where Judge Trulia had been the presiding family judge, and then he became ill and passed away in the spring, and there were several months when there was no presiding judge in family full-time. There were others who stepped into the role to help keep things moving, but no full-time. So since September of 24 until now, that total pending number has dropped from about 600 to 451 as of yesterday. The low water mark was actually about 417 at the very end of 2025, but it's like bumped up a little bit since then. So those numbers, I think, are doing well. And it's, I think, due to a couple of reasons. Number one, the branch over the last 18 months has really allocated some, I'll say, extra resources to Stamford family. Judge Diana, the presiding family judge for the state, about a year plus ago, started coming down once a week to help with our resolution plan date docket. And now, since the summer, he's been coming down once a month. So that's definitely helped because, Judge Diana is tremendous at moving business. In addition, Judge Tyndall up at the Regional Family Trial docket has been very gracious in accepting referrals from Stamford family of the longer trials, which generally trials of over 3 days or very contentious child custody cases. Judge Tyndall is taking those and handling most of those in regional. A couple of years ago, we had a trial in Stamford that went for over 58 days, and that tied up one judge. That was a couple of years ago, and that really, throws off the docket. So we try to avoid that. Also, Judge Albus is doing tremendous work in the Family Mediation Center, and Judge Albus is also chipping in on another front, and he takes a lot of our divorces on the papers and handles those for us remotely. So between all of those resources from the branch and, frankly, the hard work of the staff and the judges in the courthouse, I think we're making real progress.
Yeah, no, it sounds like triage happened, and triage is certainly working to a benefit. I mean, I've had Judge Albus, I had a couple cases that were just absolute, just barn burners, and amazingly, he was able to resolve them. And that alleviates a lot of the docket. And Judge Tyndall, I've worked with for years. So I also you obviously took a lot of time to do your backup. And there is a homework aspect to the backup. I recognize that, but I read a lot, and I read just about everything. And I do very much appreciate the very lengthy squibs that you gave us about the cases that are important to you so that I could learn why they were important to you. And you know, I just want to say that because
All right, thank you.
I do note that, and I very much appreciate the work, the time, and the attention that you put into this very serious process. So once again, congratulations on your renomination.
Thank you, Representative.
Further questions or comments? Representative Facino.
Thank you, Mr. Chair. Just very briefly, you almost certainly don't remember this, but my first short calendar appearance ever was on the short calendar in the JD of Danbury foreclosure docket. I came up doing foreclosure defense, and you were the presiding judge at the time. So I know foreclosure cases can be very tough. I know family cases can be very tough, but even since the jump, it was very evident that how equipped you were to handle these tough cases. And I appreciate how kind you were to me in my first appearance in front of the court on the public record. And I just wanted to congratulate you face to face on your renomination. Thank you.
Thank you very much.
Representative Fazzino, you did not indicate whether you were one of those attorneys who was prepared for court or unprepared for court in that question.
Representative Sashram, I'm always prepared for court.
I figured as much.
That's the company line, right?
Further questions or comments? If not,
Mr. Chair,
Yep, go ahead, Representative O'Day.
I apologize. Just briefly, Your Honor, it's good to see you. Thank you for your years of service. And just following up on the question about what's been done to triage Stanford, for those that may be new on the committee or don't recall, I am the one that asks potential judges if they're willing to serve anywhere, including Stanford family, because of it is a difficult docket. So I thank you for handling what I believe to be the most difficult docket in the state, which is Stanford family. Any other resources or suggestions that you have for us that you would suggest or request? We could certainly go offline on it, but is there anything more we can do for you?
You know, I think that as with most things, more staffing always helps. So that to the extent, even if we had another judge or two in Stanford, that would always help. And frankly, I don't think it would be a one-for-one addition where we would also need all the corresponding court staff. Because frankly, the Stanford family judges have quite a demanding docket. And I know that routinely they're spending time outside the courthouse evenings and weekends writing. So, you know, for example, if we were to have another judge, it wouldn't mean that we'd need to have that judge in the courtroom all the time, because it would really just give the judges some flexibility then to get their work done more within the confines of the business day.
Thank you for that. The good vice chair had his first short calendar before you. I think he's bragging about his age because God bless all the judges that I was before when I first was an attorney have passed away long ago. But I appreciate the fact that you handled yourself with respect and dignity for the good vice chair, and I will second those comments. You do not suffer from the affliction of robitis, and I appreciate your years of service and good luck going forward.
Thank you very much.
And Representative O'Day, I'll note for your benefit and for those who are frequent watchers of this committee that the reason we've not asked every single person today whether they are willing to serve anywhere at any time and longer than 95 is because of your years of advocacy, Representative O'Day. We have finally updated our form. So now we just ask it in written form and get the candidates to say so in writing and provide a copy of that to the chief court administrator for use at her disposal. So thank you, Judge. Congratulations on your renomination.
Thank you very much.
Next up will be the Honorable Ann Lynch. Judge, if you could raise your right hand. Do you swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. And have a seat, and whenever you're ready.
Thank you. Good morning,
Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and all the distinguished members of the Judiciary Committee. I am honored to be here before you today. I would like to thank Governor Malloy for first nominating me in 2018 and Governor Lamont for nominating me for a potential second term as a Superior Court judge. Since my appointment to the bench, I've served in the Judicial District of Hartford, Wyndham, and Torrington. I have been assigned to the GA in Hartford, was a presiding civil judge in Putnam, and currently have a block assignment in Torrington, where I handle civil, family, criminal, and occasionally juvenile matters. I feel very fortunate to have such a challenging and rewarding job, and I'm thankful every day that I have an opportunity to serve the state of Connecticut in this fashion. I am a current member of the Connecticut Judicial Branch's Civics Academy. I have volunteered for Habitat for Humanity. I routinely participate in Read Across America. I have judged high school essay contests through the Connecticut Bar Foundation, in which I am a Sustaining Life Fellow. And I have volunteered for mock trial competitions, and as well as served on the Education Committee for the Judicial Branch, and currently am a member of the Civil Jury Instructions Committee. I appreciate your consideration, and I would welcome any questions that anyone has for me.
Other questions from the committee? Questions from the committee? Seeing none, congratulations on your renomination.
Thank you very much.
Next will be the honor for Jennifer McKeown?
Churowski.
Machurowski. I was getting there, sorry. Judge, if you could raise your right hand for me. Do you swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
Yeah.
Great. You have a seat, and whenever you're ready.
Good afternoon, Chairman Winfield, Chairman Staffstrom, ranking members, Senator Kissel and Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Jennifer Machurowski, and I want to thank you for this opportunity to appear before you to ask for your support for a second term on the Superior Court bench. I also want to thank Governor Lamont for nominating me to a second term. Since September 2018, I have had the pleasure of serving in the Tolland Judicial District. While my primary assignment has been in family court, I have also covered housing, juvenile, and civil. In September 2021, I was appointed to serve as the Assistant Administrative Judge, and in 2022, as the Administrative Judge for the district, a position I continue to hold. I also serve on the Rules Committee and the Standing Committee on Guardians ad litem. In terms of community service, I'm a member of the Connecticut Bar Foundation, and I volunteer every year to serve as a judge for their annual high school essay contest. I regularly participate in Read Across America and enjoy visiting the local elementary school in my hometown of Windsor. During the school year, I also serve as a weekly volunteer tutor and mentor for elementary students in our community through a program run by the Windsor Public Library. I've also been a guest speaker at Trinity College, and I've been asked to judge the Wesley Horton mock trial competition at UConn next month. Within the district, every year, staff and judges organize a very successful food drive to support the Cornerstone Food Pantry, which is located just steps from the courthouse and serves the Rockville community. There's no question that sitting in family court can be challenging. As judges, we have a variety of often high conflict cases before us every day, day after day. Balancing the competing pressures of efficiently managing a busy docket while also ensuring that each party is heard and seen as an individual can be difficult. I constantly remind myself that while this is my job, for the people appearing before me, this is their life, their marriage, their children, their financial future. The stakes are incredibly high, and it is essential that every party who comes into court, even if they do not agree with the outcome, has faith in the process. It is an honor and privilege to serve the people of the state of Connecticut. With your support, I would be honored and privileged to continue to serve. I want to thank you for your time, and I'm happy to answer any questions.
Senator Kissel.
Thank you very much, Mr. Chair. Judge Machurowski, it is great to see you again. How's your husband and daughter?
They are doing very well, thank you. It's good to see you.
Please tell me how old your daughter is.
She is a junior at BU.
How fast time flies. Seems
Yes.
like it was just yesterday that you are chief counsel to the Senate Republicans. And I just know that you're doing an awesome job. It wasn't that long ago. I know that I did miss the last Rules Committee invitation, but Attorney Dykes of our staff was able to attend. But the previous one, I don't even know if it's like a year ago or 2 years ago, but that you were there in attendance with Judge Armada. It was a pleasure to be there. And I just learned this afternoon, I probably should be more on top of this, that that Rules Committee was then being headed up by Judge Alexander, who's now the Chief Court Administrator. So things are changing all over the place. And the other thing I think is terrific, given where you live, my old hometown, Windsor, Connecticut, is that you, and I've noticed that you're over there in Rockville. And for when I was in private practice, I was both on the criminal side or civil side out there in Rockville. It wasn't too bad of a drive from Enfield. And it was a very nice area of the state to practice law. And so I think it's terrific because I hear these war stories that sometimes judges are far from home and they have long commutes, and it's a pleasant one, even though it may be shorter zipping into Hartford, but probably about the same. Your Honor, what do you see as far as challenges to the judicial branch? I know that early on, the good Chairman Staffstrom was talking about artificial intelligence and things like that, but the ever increasing number of pro se litigants. We heard from Judge Mall of the appellate court that 40% of cases, even on the appellate level, one of the parties is pro se. And I'm just wondering, from your vantage point over primarily in Rockville, although I know your assignment can change, but what's the world for the judicial branch look like, or Connecticut look like from where you sit?
Well, first I have to say, we are incredibly blessed in Rockville right now. We have an excellent team of judges there. They're incredibly hardworking and diligent. I have to say, as administrative judge and being in the same district now for 8 years, the new judges that you have approved are just really impressive, and they've been incredible assets to the branch and to the district. I definitely, we've been talking about it now for several years, the growing number of self-represented litigants sitting in family court. The percentage is more like 80, in Rockville, maybe as much as 85% of the cases have at least one self-represented party. And that can be challenging. And finding ways to facilitate representation, affordable representation for those parties who are trying to navigate the court system and who do have so much at stake. I don't have the answer for that, but it would absolutely benefit the individuals in the process, I believe. So that, and it's been discussed, artificial intelligence. We have had in Rockville at least 2 cases I can think of off the top of my head where briefs were submitted with clearly hallucinated sites that were simply didn't exist, were not valid. And how to respond to that, particularly when you combine that with self-represented parties who are not subject to the same rules of professional conduct and who are not as likely to be aware of the rules, the procedural rules and filing rules. It's definitely a challenge.
I often wonder, you're in an interesting position, like the state of educators today, and I'm not even necessarily focusing on secondary education, junior high or high school, but college professors, with access to artificial intelligence and these sites and software and algorithms, how can they monitor what's real, what's fake, what's real research, what's just push of a button research? And I'm just wondering, what is it that you can bring to bear other than your vast intelligence and experience based upon your years of practice as to what, looks authentic and what you have doubts about? Because I'm just wondering what are the tells? What are the giveaways?
Well, the 2 briefs that I mentioned were in civil matters, so they didn't come directly to my attention. They were caught by the judge. So the judge or perhaps the opposing counsel. But again, if it were a self-represented party on the other side, you can't expect them to be able to catch hallucinated cites to cases, erroneous citations, et cetera. As far as I know, we don't have a filter, like a program. I know universities do. I know this from my daughter because she's been warned about it. So I don't know whether that's something the branch is looking at, but right now you're really relying on the judge, the opposing counsel, someone with eyes on it to find it and bring it to the court's attention.
And you being the judge, how do you spot it?
Again, the two cases in Rockville were not family cases, so it was the civil judge who, in one case, I believe there was just something off about it. He just found the site to be, something seemed off about it. The other, the opposing counsel brought it to the court's attention. I don't know. I don't have 100% faith that we would catch every hallucinated site or erroneous site that was generated by AI. And that's a problem. As I said, at this point, we really are relying on the judges and the opposing counsel and the parties to bring it to the court's attention.
Okay.
I will say this, if it's in a brief and you're writing a decision, the judge is going to check those. I mean, certainly the judge is not going to rely on and cite without doing their own due diligence and checking it. But the question is, short of that, until you get to that point, how would it be brought to the court's attention?
So I don't think we're at the point of dire straits just yet, but I think that there's some looming trouble on the horizon, and maybe some resources will be requested by the judicial branch to better allow our judges to be able to review briefs for the utilization of AI that may not be spot on. The other question that I had is that my recollection was that Yukon incidents would end up in Rockville Court. Is that still the case?
Many, if you're talking about the criminal cases, many of them are heard in Rockville.
And just based on your years of experience, and maybe you don't sit in criminal, maybe you do, but certainly at lunch break, I'm sure you're chatting with your colleagues, whoever happens to be assigned there. But how is the state of the wonderful my alma mater, University of Connecticut at Storrs?
I guess if you're asking, has there been a noticeable uptick in cases or both either in volume or severity? I don't think we're seeing that. So there's nothing that's raised a red flag as far as I know.
That's reassuring. One last thing, Judge Maczarowski, I guess here's your opportunity not only to seek confirmation of your renomination, and congratulations, it's going to be smooth sailing. And it just seems like yesterday that we were talking right before you were first nominated to the bench. But is there anything that you want us, especially given the fact that you were counsel to one of the caucuses for a number of years, and I know that you care passionately about justice, and so you've seen how it works from this side. Is there anything that you want we as legislators to take away that can either be of assistance or we should be forewarned and thus forearmed regarding what's going on in the judicial branch or the kind of cases that are seen coming before you?
I will say that since COVID, the number of restraining order applications, for example, I think we've seen an uptick in that. I think it reflects, society, what's going on in our society, some of the pressures that people are under, whether it's financial or otherwise. I would say continue to invest. We have excellent family relations officers and a family relations office that screens those cases, that meets with the parties. They're invaluable in both restraining order and domestic violence cases and in family cases in general. They provide a great service. In family cases, the number of cases that would benefit from a psychological evaluation or fairly intensive mental health services. I think, we're seeing upticks in those types of cases, and the services available in the community are sparse. Certainly services that are covered by insurance or that are affordable for most folks. Family relations can pick up the slack a little bit, but it's not the same as a full psychological evaluation by a PhD psychiatrist or a licensed therapist. So I think that's a challenge. A lot of that comes down to resources, right?
And certainly your experience here working with us in the legislature, you know that it's always a struggle for which areas get the dollars. I gotta say, my recollections of working with you remain vivid and clear. You were a wonderful, wonderful attorney for myself and my colleagues while you worked for the Senate Republicans here in the legislature. I remember even prior to that when you were Jennifer Butler. I just think that it's a tremendous benefit to our constituents and the state of Connecticut that you're now in this role. And I wish you the very best for another 8 years on the bench. Congratulations, Judge Matrowski. Thank you, Mr. Chair.
Thank you very much, Senator. I appreciate that.
Representative Fishman.
Thank you, Mr. Chairman. We have to be careful with the psychological evaluation. They're extremely costly. A good one costs like $10,000. So you got a divorce, you're talking about 20,000. I mean, our system already allows for those if custody or visitation is at issue. It's already in the statute. But opening it up to other aspects of family law, we have to be really, really careful when we're doing that. Because at the end of the day, like on a regular divorce, yeah, a lot of people, he's crazy, she's crazy. Okay, you're both crazy. Where's the stuff going? That's ultimately the issue. And then the result could be that they both have, there's a lot of mental health issues going around now. Is it really relevant to disposition of assets in a divorce? So, the Standing Committee on GALs, what's going on with that? Are they meeting?
Oh, yes, they meet on a monthly basis.
Talking about what?
It is the committee's job to maintain the list of qualified GALs. GALs have to go through training and be certified that they've been through that training. They have to do continuing legal education. They have to maintain their registration. So it's the committee's job to maintain the list, to make sure everybody on the list is qualified. And it's the committee's job to review any complaints that are filed against GALs, much like akin to an ethics complaint at the Ethics Commission. So that's the primary role of the committee, and they do meet on a monthly basis.
Okay. And I mean, because I haven't heard a lot about GAL since we dramatically changed the system. And I did go through the training. So, Judge McNamara maybe go through the training so she could appoint me on cases. But I haven't heard anything out of that committee, and I didn't know.
So the committee was actually formed as a result of those reforms that you're speaking of.
Yeah, I thought it sunsetted though.
No,
Yeah,
that's a
obviously.
standing committee.
Okay. Well, I learned something every day. Congratulations on your renomination.
Thank you. And just to swing back on the side, I certainly didn't want to come across as recommending that we expand the kinds of cases that qualify for psychological evaluations. What I was commenting though is that I do think there's cases that could benefit, cases already eligible for them that could benefit from them who simply can't afford them. As you pointed, they're simply too expensive. And so we tend to rely on family relations to try to fill that gap a little bit through comprehensive custody evaluations or into issue-focused evaluations or through other services. But there are, there's a subset of cases that would benefit from a fuller sort of 360-degree psychological evaluation that a licensed psychiatrist can perform. But certainly in Rockville, most people cannot afford.
Go ahead, Representative.
Thank you. The vacuum that happens is You're talking about cases where there is no DCF intervention, there is no juvenile court intervention, where you can have, you know, wraparound services, right? So the family court is set up that even if you said you identified those cases and you said, yes, we're going to have a determination, it really doesn't have the wraparound services to do anything with that going forward. So that's an overhaul of the entire system. Otherwise, go to juvenile court, which you hope that most families don't end up in juvenile court.
Correct.
So that's the balance. But anyway, thank you. Thank you, Mr. Chairman.
Thank you. Judge, just one final question for you. So I know you mentioned the soup kitchen in Rockville, and certainly I commend your work on that. Last time I was out there, somebody mentioned something to me about that and said there's an issue with the branch and not the concern that maybe soliciting donations could be seen as some sort of ethics violation. I'm really hoping that's not true.
No, it was myself actually. who,
Yeah.
Followed up with.
I was trying not to out you. I was going to let you be anonymous.
I'll go ahead and out myself, I guess. So when you had come to the district and we were thrilled, we don't get a lot of visitors, distinguished visitors to Rockville. I wish we had more, but I know you came for the Bar Association event. And we had a discussion about community service, because I know that it's something that this committee, all the members in this committee, really want to encourage judges to become involved, to take the robe off and become involved in the community. And we do the annual food drive. Staff contribute, judges contribute a lot. We take literally trunkfuls of food to the Cornerstone Pantry, generally between Thanksgiving and Christmas. And that's a great event. But I had thought, particularly this past year, because we had heard that demand was noticeably higher than previous years, I thought, as judges, we can do more than just drop off the cans of corn and stuffing and, pasta, that maybe we could all pool together, make a financial contribution. There are other services that Cornerstone provides besides the pantry. They provide shelter services, transportation services. And so that was my thought, was that perhaps we could do that. It was suggested to me that I might want to run that by the Ethics Commission or the Ethics Committee within the judicial branch, which frankly kind of surprised me, because I'm thinking, what could possibly be wrong about us all chipping in some money and donating to the local food pantry? Or nonprofit. But the response that came back was that as administrative judge, my asking judges to even make that contribution could be problematic. Certainly wasn't my intent to make people feel pressured to make a contribution, but also that if we went ahead and did that and then a party appeared before us who was a beneficiary of the Cornerstone services, that it could possibly create a conflict situation. In light of that, we didn't do it. And I think it's unfortunate, because I think there's value. Certainly we all can make individual contributions, right? We all can write individual checks, and we can do things as I serve as a tutor and mentor in Windsor, which is outside of Rockville. But I think there's a benefit to judges in the district that they serve showing up in the community and showing that they care about the people who are coming into their courtroom. For many of us, we're going, I live in Windsor, that's not part of Rockville's district, right? So when people come into our courthouse, they see judges who aren't necessarily from their community. There's often turnover. A lot of judges, they serve. I'm lucky enough, I love Rockville and I've been there 8 years, but that's the exception, not the rule. Often it's a different, next year it might be a different judge. So from the perspective of the people that we serve, I think there would be value in judges doing community service in the districts that they serve as judges. But there is a chilling effect when you receive an ethics advice that suggests, hold up, that could pose a conflict or, just pose an issue. Because the last thing you want as a judge is an ethics complaint against you either. So that was what I think I shared with you.
Well, no, I appreciate you going back through that for me and highlighting that because frankly, we've heard it before where judges say, hey, I'd like to do more in my community. I'd like to be more involved. I'd like to be a better representative of the state of Connecticut, given that, I serve in a high profile role within state government, but those ethics people over there tell me I can't do whatever. And so I don't know who out there's listening, but I think it's high time the branch look at its ethics policy and figure out how to loosen that, and make sure that we are not handicapping judges' abilities to, um, be engaged and involved community citizens. I mean, I think it's something we look for in our judges certainly up here, and I think the branch needs to take a hard look at that. So thanks for highlighting that. See you nothing further. Thanks for being with us this morning.
All right. Thank you all very much.
Stephanie McLaughlin. Judge McLaughlin, if you'd raise your right hand for me. I do swear or affirm as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth. So help you God or under penalty of perjury?
Yes.
Great. Take a seat and whenever you're ready.
Thank you. Excuse me. Good afternoon, Chairman Winfield, Chairman Staffstrom, Senator Kissel, Representative Fishbein, and all the distinguished members of the Judiciary Committee. I'm honored to have the opportunity to appear before you today. I want to thank Governor Lamont for nominating me for a second term as a Connecticut Superior Court judge. I was appointed to the bench in 2018, having been nominated by Governor Malloy. During my time on the bench, I've been assigned to the Stamford and Bridgeport judicial districts. In my first year as a judge, I was assigned to geographic area 20 in Norwalk, handling criminal matters. The next 3 years, I handled family matters in Stamford. Over the past 4 years, I've handled juvenile matters in Bridgeport, working with an incredibly dedicated group of staff, attorneys, and probation officers. I've been the presiding judge for the juvenile court in Bridgeport for the last 3 years. During my time on the bench, I also served on the Rules Committee. I've participated in the branch's Civics Academy, annually participate in Read Across America. Also, when able, judge on mock trial competitions and in essay contest competitions. The last 8 years have been incredibly challenging and rewarding. I am privileged to serve the people of the state of Connecticut as a Superior Court judge, and I would be honored to serve the people for another term. I appreciate the committee's time and consideration. I know it's been a long day, and I welcome any questions you may have for me.
Questions from the committee? I don't see any, and so let me just commend you. You've had some, Representative O'Day, maybe, well, I'll go first, and I'll let Representative O'Day jump in because my guess is he's gonna echo what I'm gonna say. But you've had some tough assignments, family in Stamford, juvenile in Bridgeport, and your comportment score is perfect. I don't know that I've ever actually seen a perfect comportment score before. So you certainly deserve a commendation for that. So thank you and congratulations on your renomination. Thanks for service. Representative O'Day.
Thank you, Mr. Chair. And I was just going to actually kind of follow up on that. You had mentioned in your papers that juvenile was your quote most rewarding, and with those kind of scores, there's probably a reason for that. But why is this your most rewarding assignment?
Sure. Thank you for the question, Representative O'Day. As I mentioned in my opening statement, I'm really lucky to be at the Bridgeport Court. The staff there, and by staff, I mean everyone from the attorneys to the probation officers to the court staff, are tremendously focused on how are we going to help families. So kids walk in through the building on the delinquency side, and certainly we ensure that those kids take accountability for what they've done as far as their delinquent conduct. But right next to that is, what are we going to do to make sure that this child has what they need to make sure they don't end up in the criminal justice system, right? So And on the child protection side, it's what can we do for these families to help them sort of right their ship and stay somewhere positive so that the family as a whole can move forward and excel. So I think being part of that type of team effort for me has been incredibly rewarding. So
And, you know, I'd ask Mr. Clow any words of wisdom, but with perfect scores, we probably should have you do some of the judges training for the new upcoming judges on comportment. So thank you for your years of service and continued good luck. And please pass on my regards to Mr. Casson.
hey, thank you. I will do. Thank you, Representative.
Thank you.
Congratulations, Judge. Thanks for
Thank
being
you.
with us.
Thank you. Thank you, everyone.
Judge McShane will be next. You'd raise your right hand for me. Do you swear or affirm, as the case may be, the information you provide to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. Have a seat and
Thank you.
whenever you're ready.
Good afternoon, Chairman Winfield, Chairman Safstrom, ranking members Kissel and Fishbein, and the rest of the distinguished members of the Judiciary Committee. My name is Pete McShane, and I would like to thank you for your consideration for nomination for reappointment to the Superior Court. I would also like to thank Governor Lamont for renominating me for another term as a Superior Court judge. I'm extremely grateful for having had the opportunity to serve for the last 8 years. It has been challenging and demanding, yet also extremely rewarding. I'm currently assigned as a criminal judge in Milford and have tried cases in both the Part A and Part B courts. My previous assignments have included 2 years at the Part A as a Part A criminal judge in Bridgeport, where I tried approximately 15 jury trials, conducted over 10 hearings, including violation of probation hearings, hearing of probable cause, and 1 court trial. Of the 15 jury trials I completed to verdict, 7 of them were murder trials. Before being a judge, I was before being a trial judge, I was the presiding judge at GA2 in Bridgeport. Other assignments include GA work in Ansonia, Milford, and Derby, as well as Manchester. Outside of the court, I've taken part in Read Across America every year since I've been appointed to the bench. I've also had coached a middle school mock trial team for the last 14 years. I have served as a judge in the Quinnipiac mock trial competition. I actually get to do the finals every year, which is quite rewarding. And I have also taken part in the American College of Trial Lawyers Trial Practices Training Program. I am grateful, very grateful, to have had the opportunity to serve the public as a Superior Court judge in the last 8 years. And I've worked with colleagues and staff for whom I have the greatest admiration and respect for. I would be honored to be reappointed for another term, and I would be happy to answer any questions that you may have.
Representative Fishbein.
Thank you, Mr. Chairman. Congratulations, sir, on your renomination.
Thank you, Representative.
You know, the mock trial with the middle school kids, I've done that for years. It can be such a rewarding thing. I remember a couple of years ago where a young man couldn't figure out how to argue the hearsay objection, and I'm coaching him through it. And I was so proud of him because I was able to bring him out. It's great to see those kids do their thing.
It is wonderful. I have 10 state championship rings
Wow.
from being with them, and I have about since over the 14 years, I probably have about 18 of my students have become lawyers. One of them last year finished clerking at the Supreme Court.
Yeah, isn't that fantastic? A
amazing.
couple years ago, we had one of the teams that I was involved with. They got the state championship, and I was proud to have them in the house.
What school?
It was DAG.
Yeah, that's right.
Yeah,
Always a strong contender, DAG.
yeah. So it's fantastic.
Well, for
You know,
years-
the other thing that's fantastic about your backup is the last case that you mentioned, the Marcano case, which I've never seen that happen before. I don't know, you have a lot more experience, but essentially what I gleaned from this is, you know, it's a possession of assault weapon, large capacity magazine, risk of injury case, you know, so very significant case. In jury trial, they start to select the jury. And defendant's probably there and they pick 4 of the jurors and defendant says, nope, I don't trust these guys. I trust that guy.
Yeah.
And they switch from a jury trial to a courtside trial, which, yeah,
It took a lot of guts. It took a lot of guts for
Yeah.
the trial lawyer to do that, and it paid off for him. I'll just say that.
well, and I mean, it shows a lot for you and, so I've never seen that before. I thought it was quite amazing. It really speaks to your, demeanor, the trustworthiness, the neutralness that you exude in the courtroom.
Thank you. Thank you
So
for the
once
kind words.
again, congratulations on your renomination.
Thank you.
Further questions or comments from the committee? Seeing none.
Sorry.
Representative O'Day, yep, my apologies, Representative O'Day, go ahead.
No, I'm sorry. I know it's been a long day. Just real quick. Good afternoon, Your Honor.
Good afternoon.
Representative Callahan wanted to make sure I said something. He got called out to an environmental screening meeting, but he served with you, I guess, and professionally. You guys interacted, and he wanted to make sure I mentioned to the committee and to anybody listening that your reputation precedes you. Your first term as a judge has been nothing but outstanding, and all the feedback we've gotten back, and I would second that. I know your family, and they're all proud, and congratulations on your nomination and continued success. Thank you, sir.
Thank you. Thank you for the kind words, and thank you for your representations.
Senator Winfield.
Thank you, Mr. Chair, and good afternoon, Judge.
Good afternoon.
In answer to the question about complaints being filed against you, oftentimes we struggle to know anything really about what happened there, right? We get dismissed, no factual basis, dismissed time bar, dismissed, and we don't really know what happened. But what I will say is we often get very little except for that. You have chosen to characterize several of these, talking about the rambling nature of them.
Yes.
And that's different than what we normally get. I don't know, honestly, reading it, if I take that as a positive or a negative, but could you talk about why you chose to do that?
Well, yes, I've watched the game film, so to speak. That is questions that this committee has asked people up for renomination. And one of the questions has been, there's a common theme in the complaints filed against you. I thought I would head off a question by answering that up front. I could tell you one individual filed 3 complaints against me. In fact, the ink wasn't even dry on the response when he filed the next one. And if there was a common theme in any of those, along with the other one that was filed, it was they were rambling, difficult to understand. I couldn't really put a finger on what the complaint was, other than I would not let them speak in court because they were represented by an attorney. So I thought it would make things easier. Apparently not.
I'm not suggesting anything one way or the other. I will say, though, that given the limited amount of information we have, characterizing in that way could be taken certain ways. So, right. So I wanted to get a clear sense of what you were attempting to do in using the language you use. I mean, the individual is not before us. They're not on trial. None of that. I get that. Right. But someone in your position stating that this person was rambling or anything is something to pay attention to. So I appreciate you answering my question. Thank you, Mr. Chair.
Further questions or comments? Further questions or comments? Seeing none.
Thank you very much.
Congratulations on your renomination. Judge Margarita Moore. Do you swear or affirm that the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
So swear.
Great, thanks. Have a seat whenever you're ready.
Good afternoon, members of the Judiciary Committee. My name's Margarita Hartley Moore, and I want to thank you for the opportunity to appear before you today. I'm grateful to Governor Lamont for nominating me for reappointment to the bench. For nearly 8 years, I've had the privilege to serve as a family court judge. The work in family court is a team effort.
I could not do this without the dedication of the court staff. I want to thank the clerks, family service officers, marshals, court reporters, secretaries, court service center staff, also the interpreters, the IT staff, research attorneys, librarians, and the maintenance personnel. Their commitment and hard work make it possible for me to serve the people of Connecticut effectively. I would also like to thank Justice Alexander, Judge Faceto, and their staff, and also Judge Bizzuto and Judge Diana for their support and leadership. It would be a privilege to continue to work with these dedicated people and to serve the residents of the state for another 8 years. And I want to thank you for your time and consideration, and I would be happy to answer any questions.
Questions from the committee? Are there questions from the committee? Seeing none, thanks for being with us. And
Sorry, Mr. Chair, just one brief one.
Bodett, my apologies, Representative Bodett. I got to turn this laptop a little closer so I can see you there. All right, go ahead. Sorry about that.
I'm sorry, I'm not there. I apologize. Just real quick, Your Honor, thank you for your service. I note that you were in family court in Stamford from June of 18 to August of 21 as your first assignment, and then now as presiding in Milford family. Any words of wisdom on how we could help the situation down in Stamford, or what you would recommend?
Well, I could say in some ways Stanford is unique. I mean, there are a lot of folks with a lot of money, and with a lot of money also comes a lot of issues that need to be addressed by the attorneys, where you could have a case where someone makes huge amounts of money. There's 15 limited partnerships. There's cases, there's property all over the world. So you also have to appreciate that a lot of those things take time. And you have to appreciate that most of the lawyers work very hard, but it does take time to do some of the things that they need to do. And they need to be careful, because if they miss something, they could be subject to malpractice or other issues. So I know we like to put length of time, and sure, there's a lot of cases that are delayed and they shouldn't be delayed. But sometimes the length of time is necessary, especially for cases where there's a lot of income and a lot of assets. So as far as Stanford, I know Judge Kowalski is doing a fabulous job. I know they had issues when, unfortunately, my good friend Judge Trulia passed away, but they're really working hard on trying to address those issues as best they can.
Thank you, Your Honor. And again, thank you. And thank you, Mr. Chair.
Thank you, Representative Fishman.
Thank you, Mr. Chairman. Congratulations on your renomination.
Thank you.
I just wanted to ask you, in the backup, the answer to question 25, the second case appears to be a restraining order case. And it appears that the complaint was that you did not let the respondent speak during the hearing. Which, can you just explain more? I can't really tell what was going on there.
It was a restraining order.
Yeah, I got
So
that, but
both
it's not a
parties
criminal
were
matter.
there. That was her allegation, that she wasn't able to speak, wasn't able to provide all the information that she wanted to provide at that time.
Okay, so matter was dismissed. Was it dismissed after like a hearing or on the papers?
Are you talking about her complaint or the restraining order?
The complaint, it says the complaint was dismissed.
Correct.
So was that after evidence was presented that she was allowed to speak, or I'm just trying to figure out what happened here? Because I mean, on restraining order case, it's not a criminal matter, it's not a right to remain silent sort of situation, although you could get there. I just couldn't tell from here. A complaint is made against a judge that the respondent wasn't allowed to speak. And that was it.
Well, she wrote the complaint.
Yeah.
She sent it to judicial, and they dismissed it. So they didn't have a hearing or ask for any feedback from me.
Okay, so I'm looking at the process not being part of that process, right? So somebody calls me up on the phone and says, I just left a restraining order hearing and restraining order was issued and I'm the respondent and the judge didn't allow me to speak. I'd be pulling a transcript.
Well, they may have. I don't know what they did, but
Okay.
she was allowed to speak. I
Okay,
think it
so
was
that's-
her understanding that she wasn't allowed to speak.
Okay,
where
so
she was.
it's your position that her allegation was totally untrue.
Yes,
Okay,
yes.
got it. Thank you. Thank you, Mr. Chairman.
Further questions? Seeing none, thanks for being with us.
Thank you.
Next up would be Maureen Price Borland. You could raise your right hand for me and do swear or affirm as the case may be the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? Great, and whenever you're ready.
Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and all the distinguished members of the Judiciary Committee. Thank you, Governor Lamont, for nominating me for a second term. And thank you for being here today and giving me this opportunity to appear. Since my appointment to the bench in May of 2018, I strive to honor this opportunity that I've been afforded. I've diligently worked hard to advance the skills required of a judge, which includes being legally prepared to take the bench, being mindful of the dignity and the humanity of those who appear before me, and to make decisions that are fair and equitable. I've had the following assignments since my appointment. I started out in the New Haven GA for 3 months, where I presided over criminal and motor vehicle, followed by Middletown GA and Housing Court for 1 year. And then I did 3 years in the New Haven Family Court. I subsequently went to the Meriden Court, where I served as family judge for 1 year and 2 years as a presiding judge for family, civil, and criminal, primarily sitting family. I'm currently the presiding judge for family in the Middletown JD. Prior to my judicial appointment, I served as the executive director for Community Partners in Action, which is a 150-year-old community justice organization that provides a myriad of residential and non-residential services to justice-involved individuals. I've also served on a wide range of local boards, committees, cabinets prior to my appointment, and of note, the Connecticut Sentencing Commission. I was an adjunct professor at Central Connecticut State University for 17 years, teaching in the area of criminal procedure, introduction to criminal justice, and diversity in the criminal justice system. I'm currently a member of the Education Committee within the judicial branch, and I have served as a mentor to law students. And in this particular case, at this point, I'm serving as a mentor to an individual who's in law school and one who has graduated. I've participated in Read Across America on several occasions. I want to express my deep gratitude to my husband, Michael, and my family, who have been a huge support in this journey. I would be deeply grateful to continue this work of service to the people of the state of Connecticut, and I'm open to any questions that you may have.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Judge, congratulations on your renomination.
Thank you.
If I was the one creating the agenda, I would have had you towards the beginning today instead of having you sit here all day. If anybody told me that you were not a good judge, I would fight them over that, because you are.
I appreciate you saying that.
Well, I've been before you, we can't even count how many times, right? In New Haven, in Middletown, in Meriden, God, we
Keep
live there.
following me around.
Yeah. Yeah, and I haven't always agreed with you. In fact, there was a particular matter that we had and I got the decision and I was not happy, but it took me about 6 hours and I understood what you were doing.
Okay.
That you were giving a young man a chance to parent his kids. And I know where that came from. And,
Yes.
and at the end of the day, I counseled my client appropriately that you did that was right for the kids. It didn't matter.
I appreciate you saying that.
And that's all we asked for,
Mhm.
right? So I totally know where you're coming from on that, and we've worked together a lot, and once again, congratulations, and look forward to being before you in Middletown soon. So thank you.
Appreciate it. Thank you.
Further questions or comments? If not, for the record, the agenda is alphabetical, Representative. It was not in order of.
Just so that you know, when I've run boards, commissions, sometimes I go in reverse alphabetical. Sometimes I mix it up.
I will.
Amen.
Well, yeah, if Judge Spallone had put in a nice request earlier, maybe we would have done that, but since he didn't, he was at the end. All right, thank you, Judge. Appreciate you being here. Congratulations on your renomination. Yes.
Oh, thank you.
I mean, you can stay if you want, but. Judge Rosen. Judge, if you could raise your right hand for me, do you swear or affirm as the case may be, the information provided this committee be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? I do. Great. Have a seat, and whenever you're ready.
Thank you. So because of where I am in the alphabet, I had a good morning, good afternoon, and good evening prepared for Senator Winfield, Senator Staffstrom, Senator Kissel, Representative Fishbein, and all the distinguished members of the committee. I'm Stuart Rosen, and I'm pleased to be here before you today for my renomination hearing. I'd like to express my sincere thanks to the governor for nominating me for a second term as a Superior Court judge. After being confirmed in May of 2018, I was assigned to the Manchester GA Court, where I handled Part B criminal matters for approximately 15 months. In September of 2019, I was assigned to the Enfield GA Court, where I was the presiding judge handling Part B matters for about 6 months until the COVID pandemic shuttered that courthouse. I served the remainder of that term in the Hartford GA. In August of 2020, I was assigned as the assistant administrative judge and presiding judge in the Meriden JD and GA, and I continued to handle Part B criminal matters there as well as administrative responsibilities. In September 2021, I was assigned to the Hartford Judicial District, handling civil matters, including jury and bench trials, motion practice, pretrials, and mediations, where I have continued to serve since that date. I'm extremely grateful to have had the opportunity to serve as a judge. I find the work challenging and rewarding, and I hope to have the opportunity to continue to serve. I thank the committee for its consideration and would be happy to answer any questions that you may have.
Questions or comments from the committee? Seeing none, Judge Rosen, thanks for sticking with us today. I will just note for the record, I had the opportunity to appear before Judge Rosen, what was the judge, a couple months back. Your mediation skills and style, I think, are something to be commended. And I know as you're coming up on mandatory senility at some point here.
I was hoping nobody would say that out loud on the record, but yes.
I do hope that you will continue on serving, particularly given your mediation skills and style. I think you really are an asset to the bench in that regard. So
I very much appreciate that.
Thank you. Thanks for being with us.
Thank you.
Judge Sanchez Figueroa. If you could raise your right hand for me, do you swear or affirm as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. Have a seat whenever you're ready.
All right, thank you. Good afternoon, Chairman Winfield, Chairman Staffstrom, ranking members Kissel and Fishbein, and distinguished members of the Judiciary Committee. I appreciate your consideration of my nomination for reappointment to a second term as a Superior Court judge. I would also like to express my gratitude to Governor Lamont for his confidence in nominating me to serve in this position. Since my appointment to the bench in 2018, I've been assigned to the judicial districts of Middletown and New Britain. While in Middletown, I was assigned as the presiding judge of the juvenile and family courts. I also had the opportunity to preside over cases in child protection session and in the criminal court. After that, in 2024, I was assigned to the family court in New Britain until this past September, when I was assigned to the New Britain Juvenile Court, where I currently remain. Additionally, I've had the privilege of sitting in various judicial committees. In 2021, I was honored to be named the chair of the Judicial Branch's Advisory Committee on Cultural Competency. I served on the Judicial Branch's Education Committee for several years. Outside of court, I've also participated in the Read Across America program. It has been an honor and a privilege to serve the people of the state of Connecticut as a Superior Court judge. And I would be most grateful for the opportunity to continue to serve in that role. To that end, I thank you for your time, and I'm happy to answer any questions that you may have.
Representative Fishman?
Thank you, Mr. Chairman. Congratulations on your renomination.
Thank you.
You're welcome. I wanted to ask you about the Northman complaint, and I know that's pending. Well, is it still pending?
No, it's not.
Okay.
I received a letter just a few weeks ago that it was dismissed.
Okay.
But I should also say that there's an appeal pending from the same person.
On the dismissal of that?
No.
Oh,
on
there's
the
appeal pending on your underlying ruling on
decision.
the motion.
Yes.
Okay. Yeah, that's not as much of a concern to me, quite frankly, for what's before us. But I wanted to ask that complaint. So you went to juvenile in New Britain in September, but the Northman complaint was filed in November of 2025. So based upon what it has to do with, I would think that that has to do with some alleged conduct prior to your transfer to juvenile.
Not a conduct, but my decision, my memorandum of decision, which I believe I submitted either September or October for a post-judgment hearing I had on that matter.
Yeah, okay. But when I say conduct, he alleged some sort of
Correct.
bad conduct as a result of
While
that.
I was in family.
Yeah, which you
Yes.
heard while you were in family. So
Correct.
can you just educate me, what is presently, if there is one, the period of time in which one must allege a violation or an alleged violation by a judge after that bad act?
I'm not sure. I'm not sure. Maybe when the decision, he reads it and it sinks in. I have no idea. I don't think there is a deadline. There's
Because I know we had one of the judges earlier today who brought to our attention in the backup that the complaint against him was filed a year afterwards, and was still pending at the time of the submission. So I don't know. I mean, it's not necessarily a tort, so I don't know. I thought maybe you would know, but anyway.
no, well, in this situation, it wasn't a year, maybe 2 months.
Yeah, in your
after-
particular case,
Yeah,
right?
Yeah.
But we had the other one where it was a year and they didn't just dismiss it on the paper saying you're too late, right? They, in that one. So, maybe there needs to be a date. Anyway, okay, well, congratulations once again and look forward to
Thank you.
seeing you soon.
Thank you.
Senator Winfield?
Just to be clear, that letter that you got that dismissed it, it was no factual basis. Is that what it was?
Yeah, based on the evidence that I had not violated any of the judicial code of conduct.
Okay, thank you.
That was the letter that I received. And I did submit an update as well.
Further questions or comments, Representative Osborne?
Good afternoon, Your Honor. It's nice to
Good
see you again.
Thank you.
I just have it's an idle curiosity for folks who have served heavily in juvenile and family court. I'm curious because, you had family support magistrate experience before being appointed to the full bench. What was your professional background before you were appointed as a magistrate, if you don't mind sharing that?
I practiced, I was a solo practitioner for 18 years.
Okay.
And my practice was, I'm going to say 95% family, which included family support as well. Maybe a handful of juvenile matters.
Thank you very much.
You're welcome.
Thank you, Mr. Chair.
Further questions or comments? Seeing none, congratulations on your renomination.
Thank you.
Joseph Schwartz.
You could raise your right hand for me. Do you swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. Have a seat. Whenever you're ready, we'll take the opening statement.
Thank you. Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the committee. Good afternoon. I'm honored to have this opportunity to appear before you today. I want to thank Governor Lamont for nominating me to serve a second term as a judge of the Superior Court. I was first appointed to the bench in 2018, and since that time, I have served in the judicial districts of New Haven, Waterbury, Meriden, and in Hartford. My first assignment was in GA 23 in New Haven, where I presided over Part B criminal matters. In January of 2019, I was moved to Waterbury, where I continued to preside over Part B matters. In September of 2021, I became the presiding judge in Meriden, where I continued to preside over criminal, civil, and family matters. In September of 2022 through September of 2025, I moved back to Waterbury, where I became the presiding judge over Part A and Part B matters. Most recently, I was moved to Hartford, where I am currently presiding over Part A trials. It's been an honor and a privilege to serve the people of the state of Connecticut as a Superior Court judge. I hope to have the honor and the privilege of continuing to serve as a judge in a new term of office. Thank you for considering my application.
Questions or comments from the committee? Questions or comments? Good.
I know that all of them are dismissed, but you have a lot of responses to question 25. I don't know. I guess I just ask you, do you want to make commentary about that? I don't think it would be appropriate to just not touch that, given the number that there are there.
Sure, I did answer question 25. I provided a summary of each of those decisions. None of them had to do with my judicial temperament.
Okay. Representative Fishbein.
Yes, thank you. Looking at two of those, they appear to be small claims matters.
They do.
And can you, because I thought that magistrates sit on small claims. Can you just explain?
They typically do. During COVID, Superior Court judges were assigned to do small claims matters.
Okay, thank you. Once again, learned something else today. So, thank you. Yeah.
Further questions or comments from the committee? Further questions or comments? If not, thanks for being with us. Congratulations on your renomination.
Thank you.
All right, last but certainly not least, Jamie Spallone.
Mr. Chair,
Representative O'Day.
sorry to interrupt.
Go ahead, sir.
I have a pending matter before the Honorable Judge Spallone, and in an abundance of caution, I am going to recuse myself from the committee meeting. Thank you.
So noted. Judge Spallone, if you could raise your right hand for me. Do you swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. You can have a seat, and whenever you're ready, we'll take your opening statement.
Thank you, Mr. Chairman. Members of the committee, I've streamlined my remarks in light of the long agenda. Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee, thank you for the opportunity to provide an opening statement regarding my renomination. Thank you also to Governor Lamont for sending my name to you for consideration and to his staff for their assistance throughout the process. 8 years ago, I walked down from my office on the 4th floor here to appear before you for my first public hearing as a nominee for the bench. Since then, I have enjoyed the opportunity to serve the people of the state of Connecticut as a trial judge in 3 of the court's divisions: criminal, civil, and family. I have worked in 5 courthouses in 3 judicial districts, including New Haven, Derby, New London, and Norwich. Since September 2024, I've been sitting as a civil trial judge in New Haven. It's a very busy courthouse with constant trials. My days consist of pretrial settlement conferences, trial management conferences, hearings on motions, and many trials before the court and jury. I have enjoyed all of my assignments and have found each discipline challenging, fulfilling, and interesting. My range of experience in private practice, as well as my prior service as a member here and a member of the staff at the legislature, and as Deputy Secretary of the State, prepared me well for the variety of work a trial judge undertakes and the people we encounter on a daily basis. Again, thank you for the opportunity to speak this afternoon, and I do look forward to answering any questions you may have.
Are there questions for Judge Spallone? Senator Kissel.
Thank you very much, Chairman Staffstrom. Well, Your Honor, congratulations on your renomination. I just want to reiterate what a pleasure it was serving with you here in the legislature. And would you say that this is the best chapter of your life and you're looking forward to 8 more years on the bench?
I'm looking forward to 8 more years on the bench, certainly, and I've enjoyed every day that I've gone to work. I don't look on it with trepidation. I look forward to it. I find it challenging, as I said. And I did enjoy every day I came here as well.
Thank you very much. And again, congratulations. Thank you, Mr. Chair.
Further questions or comments? If not, Judge Spallone, I can't believe it's been 8 years. That went pretty quick. It seems like you were just working with us yesterday. So thank you and congratulations on your renomination.
Thank you, Mr. Chairman. Thank you, members.
All right, that concludes our list of nominees. We do have a few members of the public who've signed up to speak with us, so we will go through that. First on my list is Robert Burke. Is Robert Burke with us? All right, if not, we'll go to Ed Gavin.
Good afternoon.
Attorney Gavin, unless you want to be a judge, you don't need to swear.
Sometimes you do, sometimes you don't.
No, you're good. You're good.
Thank you.
We don't need to swear you in.
Thank you very much. Chairman Winfield, Chairman Staffstrom, Senator Kissel, Representative Fishbein, and the distinguished members of the Judiciary Committee. My name's Edward Gavin. I'm a lawyer in Bridgeport, Connecticut. I'm the past president of the Connecticut Criminal Defense Lawyers Association, an organization of 350 criminal lawyers licensed to practice in the state of Connecticut. This is my 18th year appearing before this distinguished committee on judicial reappointments. Our members are given a list of the judges that are up for reappointment. And we ask that they provide comments to us and provide their name and, if necessary, provide comments without providing their name. This year, you have a huge group of, obviously, judges that are up for reappointment. I think next year there's only 3. So you're putting in overtime today. But there is an outstanding list of criminal judges. We have submitted to each and every member of the committee our submission. It's about 50 pages long. And there are many judges that are notated in the commentaries that we don't practice in front of in family court or other areas. But this year has a group of outstanding criminal judges. We have Judge Calistro, who's done an incredible job coming out of COVID in New Haven. Judge McShane, extraordinarily talented. Judge McShane, we had the benefit of him presiding in Derby, and then as the presiding judge in Bridgeport, GA, moved over to Part A with Judge Dayton, trying very, very complicated murder cases, and is now over in the Milford Superior Court. Judge Droney is doing an outstanding job up in Hartford. Personally, I think she deserves consideration for elevation. Everyone is very, very impressed with the work she's done. Judge Dayton, who's handled the most difficult dockets coming out of COVID in Bridgeport, and then now presiding in New Haven, which has a very big docket. Judge Moore just came here. She's probably, if not one of the best family judges in the state of Connecticut. Judge Baldini has done an excellent job. I appeared before her up in the New Britain area on a complex case, and there was an issue, and she recused herself and did the appropriate thing. You also have Judge Batt, who's extraordinarily bright and came out of the New Haven Judicial District with under the tutelage of Tom Ullman, the great former public defender. And then on 2 days from now, you also have the state trial referees, and I'd just like to note Maureen Dennis is up for reappointment. Judge Dennis has been a terrific judge and fills a variety of positions and has done extraordinarily great work in her career. I thank you for the time and the opportunity to speak to you, and I'd be happy to answer any questions.
Senator Kissel.
Thank you very much, Chairman Stafford. Attorney Galvin, Ed, I can't believe it's 18 years.
18 years.
Wow. Well, thank you for being patient here all day. And on behalf of your organization, I want to extend my thanks as well. And I just want everyone to know who might be watching at home, you know, it's not just lawyers coming here and always saying, oh, we love this judge or we love that judge. Attorney Galvin and the criminal defense lawyers are not hesitant to point out flaws or real problems with certain jurists that come before us over the years. And that's extremely helpful, and it's brave on their part. They're just not out there trying to better their lot and how they perform in front of the court system. That's not what this is all about. And it's really one of the only organizations that takes the time to assist us with the judicial selection and renomination process. So I just want to extend not only my thanks to you for your 18 years of dedicated service coming before the legislature, but for all of your members as well. Thank you, Mr. Chair.
Thank you very much for the kind comments.
Further questions or comments? If not, thanks for being with us as always.
Thank you.
Guy Source.
Another Bridgeport lawyer.
Hey, you know what?
Attorney Galvin,
The
my
mo-
neighbor.
The more the merrier. You know?
Good afternoon, members of the committee. My name is Guy Soros. I am a practicing lawyer in the Bridgeport area. I've been a practicing lawyer for 39 years, going on 40. I've had a lot of criminal trials, personal injury, civil cases as a plaintiff, and I've tried a lot of cases over my tenure. I have been before most of the judges that have come before this committee today. Judge Calistro, Judge McShane, Judge Dayton, Judge Bott, Judge Schwartz. They are just the epitome of what judges should be. Fair, impartial, great demeanor. Stastrom, you had asked Judge Dayton about her demeanor on the bench and so forth. I'll give you a little story about Judge Dayton, and I don't want to take up too much of your time. However, during COVID, it was very, very difficult. And there was a lot of rumblings about trying to get cases moving. And there was some resistance. However, she pushed forward in a very judicious way to try and rally the criminal defense bar, which she did. I will also indicate that 3 years ago, I ended up with a very, very severe heart condition. And I was making my way to the courthouse, didn't make it and collapsed. Judge Dayton came out of the building and aided me in getting medical treatment. And then told me, don't worry about your cases today, Guy. I'll take care of them. And she did. And she did it in a way that protected not only the rights of my clients, but the rights of any potential victims that were there for those proceedings that day. She then kept track of me while I had to take a period of time off from my practice due to the illness. And was very, very instrumental in making sure that victims' rights were protected during that time frame. I owe her a great debt, as I do to the other judges who are also aware of the medical condition that arose. I'm grateful to all of them. I would also indicate, as far as Judge Bott is concerned, I just tried a case with Judge Bott in September and October of 2025. It was a sexual assault in the first degree matter, very, very sensitive information and facts in that case. He had such judicial temperament. He was very sensitive to the factual pattern, especially through jury selection, which was very, very difficult. And going through a 6-1 jury selection, and there were a tremendous amount of people on, I believe there were 4 panels that were brought down. The amount of individuals who had a prior sexual assault against them was astounding, but he handled it in such a sensitive way that he didn't insult or offend anybody in the process and let people go about their business. I would highly recommend Judge Bott for reappointment. I think he knows the law. He's very, very cordial, and he moves the business along as quickly as he can. I thank the members. If there's any questions, I'd be happy to answer them.
Thank you. Questions from the committee? Questions from the committee? If not, glad to hear you're doing better after the health scare there, and
Thank you.
back to practicing, and thanks for being with us. I appreciate you sharing your insight.
Thank you.
Bella Leal? Sorry about that.
Sorry, I know I'm not a lawyer.
Oh, no worries.
Good morning. Good afternoon, actually. Senator Winfield, Representatives Starstrom, members of the Judiciary Committee. I'm Belle Leal. I'm 17, a high school senior from Stratford. I've lived through the Connecticut family court system. I'm here because the judges you confirm decide if kids like me get hurt or forced into therapy with abusers under parental alienation theory. In my case, despite being 15 through 17 years old, I was never allowed to speak in a courtroom. I never testified. My wishes.
So let me just, I don't mean to cut you off, but just what judge are you speaking about?
I'm speaking about all of them. I'm asking you to take this into consideration when looking at the family court judges, especially oh no, I forgot her name. I'm so sorry.
Is one of the judges who's on our agenda today, was that the judge who heard your case?
No,
Okay.
but this is a statewide issue.
So unfortunately, just because of public meeting rules, et cetera, we have to have you testify on a matter that's on our agenda today. So if it's not one of the judges, what I'll do is I'm happy to talk to you sort of after the close of the hearing, but we can't let folks testify and stuff that's not technically on our agenda today. I'm sorry about that. I appreciate you sticking with. Stick around though. I'm going to talk to you in the hallway when we get done. All right. Are there any other members of the public who have signed up to testify today who have not testified on the matters on our agenda? If not, I'm going to declare the public hearing closed, and we will see everyone again on Friday. Friday, we would pick up with a public hearing on the remainder of our reconfirmations, and then we do expect